We are on the record. My name is Colette Stark. I'm a notary public contracted by Video Solutions. I am not financially interested in this action, nor am I a relative or employee of any of the attorneys or any of the parties. Today is August 14th, 2018. The time on the video monitor is 9:31 a.m. This video deposition is taken at 225 Broadway, Suite 1900, San Diego, California. The name of the case is Taylor versus DMCG Incorporated et al., filed in the Superior Court, State of California, County of San Diego. Case number 372016 000-15444 CUOE-CTL. This is Volume 1 in the videotape deposition of the PMK of Financial Casualty and Surety Incorporated, William Shields. The deposition is taken by Attorney Scott McMillan. Would the attorneys introduce themselves and state whom you represent?
Scott McMillan on behalf of plaintiffs Will Taylor, Ken Gorman, Nicholas Whitman. Also present with me is Jessica Marshall, my associate.
Good morning. Timothy Daly, Music Peeler and Garrett on behalf of defendants DMCG Inc., McGuire Bros Enterprises, Bail Hotline Bail Bonds Inc., Financial Casualty and Surety Inc., Daniel McGuire, Gilbert McGuire, and Alejandro Topete, T-O-P-E-T-E. Also present is client representative Carmen Linez.
Good morning, Rolando Gutierrez of Gutierrez Blanco and Arias, representing Defendant Fugitive Recovery Investigations, Defendant Fugitive Recovery International, Defendant Michael Leon, and Defendant Cesar McGuire.
Okay. The court reporter today is Greta Yang with Schuler Court Reporting. She will administer the oath.
Do you solemnly swear or affirm that the testimony you will give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
Could you please state your full name?
William M. Shields,
Who are you employed by?
Financial Casualty and Surety,
What's your job function?
President.
Oh, you're the president.
Yes, sir.
Okay. How long have you been president?
I've been president for approximately a year.
And what did you do to prepare for this deposition?
The witness is certainly free to testify about what he did to prepare, but I'll instruct him not to reveal in that disclosure any communications you've had with any lawyers representing FCS in this matter. You're free to testify apart from that. I don't think Mr. McMillan is asking about that information.
I reviewed the pleadings in the matter and reviewed the questions for the deposition notice, and reviewed records and related documentation that would be required to properly respond to these questions.
Sir, are you a licensed attorney in any state?
No, sir.
And how long have you been employed with Financial Casualty and Surety?
For the period that I mentioned, approximately a year.
Okay, just 1 year. And before that, where were you employed?
I was employed for most of my career with William M. Shields, PC, which is an independent CPA firm.
Are you still a licensed CPA?
Yes, sir.
Have you ever had your deposition taken before?
Yes, sir.
On how many occasions?
Approximately 100.
In what capacity? As an expert?
Primarily as an expert, yes.
In light of the fact that you've had your deposition taken 100 times and are familiar with the litigation process, can I dispense with formalities of admonishing you about the oath that you've taken and what a deposition is about?
Yes, sir.
Okay, thank you. Before coming here today, I'm going to show you Exhibit 1, which is the notice of deposition. I actually got another extra copy of that. Did you see Exhibit 1 before coming here today?
Hang on a second, Scott. Let me take a look at this. Because, as you know, Mr. McMillan, two things procedurally. This is the first deposition notice. There was a second deposition that you notice. This is the one for the deposition in Texas, which was issued and supposed to commence on August 6th. I believe your office served us on August 10th with a second notice of deposition, and shortly thereafter, I'm going to mark as Exhibit 2.
I'm going to. I've got that.
You got the objection?
So no, don't mark it as Exhibit 2.
Well,
You can mark
mark
it as Exhibit A.
Perfect.
Because I have everything else in.
Oh, okay. Well, I don't want to screw your numbers up. So we'll mark Defendant A, which is the objection that was served on you as a result of the procedural deficiencies in the notice that brings us here today, which is not Exhibit number 1.
Well, we're going to get to that.
I hope so, because this is not the operative document for today. Would you like
Well,
a copy?
are you objecting
Counsel,
to
hang
the?
on. Would you like a copy?
I have a copy.
Okay, very well.
Are you objecting to the? Because I just looked at this and noticed
What's this?
myself.
What's
I'm
this?
going to show them Exhibit 6.
Okay.
And notice myself that it doesn't have the issues on which he is speaking as PMK.
Yeah.
So are you objecting that he's not PMK for those issues for the purpose of this?
We're objecting as set forth in the notice. We're here in good faith, Scott, to proceed. I believe it would be fair to state, without waiving the objections that Hickman served on you, that this individual is familiar with the categories 1 through 60 in the first deposition notice, which is not the deposition notice that brings us here. So we're not playing that game with you. I think Mr. Shields is more than competent, given his 30 years of experience, to answer the questions that are outlined, and he will be the PMK for today.
Okay, let's go off the record so we're not wasting the transcript on meeting for.
Off the record, the time is 9:38.
Well, I would prefer
a.m.
that since we don't have agreement to go off the record, ma'am.
Okay, so we'll just do it right now, and
Yeah.
you're going to voice the costs on me. This is the situation. I just noticed that. So I'm taking it as your position that he's just William Shields as president, not as the person most knowledgeable. And in which case, I can
that's
just
the
go
case,
ahead
we-
and renotice everybody as, renotice all these PMKs, and we do this exercise over again. I mean, is that what you want to do?
Well, I beg to differ with you, Scott, because you have no notice of Bill Shields individually, and he's not here in his individual capacity. So I think you're incorrect in that regard. We're here to proceed with the notice that you've issued for the deposition today. I've already explained to you that I'm not playing a game with you. He is the person most knowledgeable for financial casualty. So if you want to proceed today with the person most knowledgeable, he is here, he's ready to proceed. You haven't noticed Mr. Shields individually, nor is he here in his individual capacity. So either you proceed with the deposition notice that you've got, or we can suspend and you can do whatever you think is appropriate.
Okay, well, I just need to understand what matters he is person most knowledgeable about. So are you saying he's person most knowledgeable about the 60 items, or is he just generally person most knowledgeable?
I would not have the temerity to produce somebody who's just generally knowledgeable, Scott. I don't think you would either. You served an original PMK notice that had 60 categories. I'll represent to you, without waiving the objections that have been presented to you previously, that Mr. Shields is the person most knowledgeable on those 60 categories, subject to our objections to your amended deposition notice.
Okay, because the amended deposition notice, the purpose of that was just to set this hearing in as a result of the meet and confer that occurred in front of Judge Lewis and the instructions to produce a PMK. So, I mean, that's what the issue is here. And so if he's here just to talk about the 60 items, I'm fine with that. But, and he's being offered, tendered as the person for the 60 items that prompted the defendant's ex parte, fine. Otherwise, I mean, I suppose you're just going to have an objection that he really didn't have any authority or any knowledge about those 60 items if it doesn't work out for it, for the company. So I'm really not sure about what the position is.
Are you done?
Yeah.
Don't let my silence be construed as acceptance to anything you've just said, because I'm not clear what you said. My representation is as I've set forth on the record. You can either have the court reporter read it back. I think I'm very clear. You have an opportunity to proceed with who we've designated as the person most knowledgeable. If you choose to proceed today, so be it. If you don't want to go forward, then we can suspend the deposition. The call is totally yours.
We'll make the most use of our time today.
I hope so. Because we already started a half hour late.
Oh, we're going to go there.
No, we're not going anywhere. Let's get to a question.
Mr. Shields, what documents did you review immediately before coming in today?
Assumes facts, not in evidence. Speculation. You can answer.
I reviewed the notice of deposition.
Both copies?
Yes, sir.
All right.
And as I referenced previously, I've reviewed the pleading, the original pleading, just to be generally familiar with the matter. And I've also reviewed the general request for production that was provided to my company.
And in that vein, Scott, let me just...
Okay.
Sure.
Why are you talking?
Because
the only interruption you should have should be preceded by an objection.
Well, let me share with you, Mr. McMillan, I'm not, in the words of Oliver North, I'm not a potted plant. And for the record, we've produced to you today, I think, about 14 or 1,500 pages of documents in response to your request for production. That's all. Thank you.
Mr. Shields, what was your familiarity with financial casualty and surety before you started a year ago?
I've been associated with financial casualty and surety since the inception of the company. I served for all that period of time as their tax advisor and financial and accounting advisor. And for the past 8 years, I've served as a board member. For the past 7 years, I've served as the chairman of the audit committee of the company.
Thank you. Have you been involved at all with the regulatory filings with the California Insurance Commissioner?
Questions vague and ambiguous, calls for speculation. If you understand the question, you're free to testify, but I would caution you.
Yes, sir. I'm familiar with the filings. I have not reviewed each and every filing that's been provided to the California Department of Insurance.
Did you review the initial filing that was filed in 2004?
No, sir.
If I could have that. It's going to be Exhibit 301. Passing the Exhibit 301. Here you go.
Oh, thanks, Scott. Appreciate that. And this will be marked as exhibit.
It's already marked down at the lower
So
right.
just for the record, we're going to use the exhibit numbers that are on there?
Yes.
Okay, great. And I have no objection to that. Seems to be orderly and makes sense.
Do you recognize this document, Mr. Shields?
Well, hang on a second. Give him an opportunity. The exhibit's over 40 pages long.
No, sir. This is the first time I've seen this document as you presented it.
Is it common for sureties such as financial casualty and surety to file applications to engage in the surety business in states?
Question is overbroad when you refer to states, may call for expert testimony as compound. If you have an understanding, sir, you're free to testify.
I have a general understanding of the initial filing process.
Can you describe that as you understand for California, according to your understanding?
I can't describe specifically as it relates to California, but in general, the purpose of the filing is to essentially become licensed to write surety in the applicable state.
A financial casualty and surety is licensed to write surety in how many states?
Approximately 34 at this time.
If we turn to page 24 of 301, if you look at that, please. What is that page?
Document speaks for itself. Best evidence may call for a legal conclusion. You're certainly free to testify if you have an understanding of what page 24 of 301 is.
It is labeled a power of attorney for Financial Casualty and Surety, Inc.
And what is your understanding as to the effect of this document if it is completed?
This is a document that results in the company's issuance of a bond on behalf of an insurer that is essentially sold by a bail agent.
And who is the power of attorney typically given to?
Calls for speculation, vague and ambiguous, incomplete hypothetical. You can answer
Or
if you
who does it typically name as its attorney in fact?
Generally, it names our licensed bail agent.
And in this case, which of the defendants are licensed bail agents of financial casualty and surety presently?
It is my understanding that presently our licensed bail agent is DMCG Inc. And then the license is predicated on the issuance by the applicable state authority to a licensed individual agent.
Do you understand whether California has listed DMCG Inc. as a licensed bail agent for financial casualty and surety? And when I say California, the Commissioner of Insurance.
I'm not certain of the correct answer to that.
Is it your understanding that within the Department of Insurance, there is an active licensure between DMCG Inc. and financial casualty and surety?
questions vague and ambiguous, calls for speculation. You can answer if you understand it, sir.
I believe so.
And from your understanding, has that been active for the last 10 years?
My understanding is it's been active for approximately that time period.
The set of forms that are filed with the regulatory agencies, the various departments of insurance, do they generally request that you file the form of your power of attorney?
Ma'am, can you read back that question, please?
You know, I'm going to object to that, okay? Just,
She
if
can't
you
read
don't,
that?
if the witness doesn't understand the question, I'll rephrase it or repeat it. But please do not interrupt my deposition,
You know
Mr.
what?
Daly.
I'm going to defend this deposition to the broadest extent allowed by law, and I'm not going to have you bully me in this deposition. The court reporter can't type when both of us are talking. Let me finish. And you also know, Mr. McMillan, that if I ask for a readback, The court reporter can't read it back while you're talking, so be professional. I'd like the question that's pending read back.
I object to it.
Well, then he's not answering
I
it.
object to the conduct of the deposition. My objection to the conduct of the deposition is that there is an interruption that is not prefaced with the word objection.
Good.
And that is the only legitimate interruption to a deposition, is an objection.
Read back the question, please, ma'am.
The set of forms that are filed with the regulatory agencies, the various departments of insurance, do they generally request that you file the form of your power of attorney?
Question's vague and ambiguous, calls for speculation, may call for expert testimony and a legal opinion. You're free to testify if you understand it.
It is my understanding that generally the form of the power of attorney is part of the submission.
Thank you. After the power of attorney is executed in any particular jurisdiction, what is your understanding, if any, as to where that power of attorney is recorded or filed?
It's my understanding that it's filed in the court in which the power of attorney is issued for the benefit of.
Do you have an understanding why the court wants the power of attorney?
Generally, it's my understanding that the court requires the power of attorney for its records.
Do you have an understanding, as a layperson, as actually more than a layperson, as a person that's familiar with the insurance business and the bail bond business, why that is?
It's to maintain a proper record of the documentation associated with the release of a defendant of the court.
Now, you authenticated in your declaration in Exhibit 6, correct?
Exhibit 6? I don't have exhibit, oh, okay.
No, it's in Exhibit 6 to the motion for summary judgment.
Oh, we don't have that in front of us.
Okay, I'm just asking from your recollection. Do you remember your
believe so.
declaration? You prepared a declaration in this case, correct, Mr.
Yes, sir.
Shields? Okay. If I could have that declaration, Mr. Shields' declaration.
Scott, the confusion was we have an Exhibit 6, that's why I was confused.
I understand. I'm not
Apologize.
taking an issue with that.
Okay.
Can I have his declaration as well, please? Okay, I'm going to hand you Exhibit 246.
Thank you.
That's for you.
And I'm sorry, Scott, what exhibit are we making this?
It's already marked.
Oh, 246, okay, thank you. All right. I'll catch on here shortly.
Yes, sir.
You recognize Exhibit 246.
Yes, sir.
What is Exhibit 246?
It's a retail producer bail bond agreement by and between Financial Casualty and Surety, and then Daniel McGuire and other defendants in this matter.
Is this a confidential document?
You call for a legal conclusion. Also, I'll just stick on that. Don't reveal any communications you've had with counsel, but you're certainly free to testify as to your opinion.
I'm not certain.
Is this a document that's filed with the courts?
I know that it is filed with the insurance commissioner. I don't know whether it's filed with the courts or what you're specifically referring to in saying courts.
How do you know that it's filed with the insurance commissioner?
My understanding is it's available to any insurance commissioner upon request.
Okay. Well, you said you know that it's filed with the insurance commissioner. Do you actually know that that is part of the filing that the insurance commissioner requires?
It's not part of the initial filing, but it is available for review by any insurance commissioner who requests it specifically.
And that's because the insurance commissioners that request documents specifically can ask for any of the documents that financial casualty and surety has, correct?
I'm not certain of that, but I generally believe that's the case.
Essentially through their subpoena, their police powers as a regulatory agency, correct?
May call for a legal conclusion. You can certainly testify as to your understanding.
We generally submit them upon request on a voluntary basis.
Okay. But it's your understanding that this is not, our Exhibit 246 is not one of the documents that is submitted as of course with the insurance commissioners, correct?
Questions vague and ambiguous.
My understanding, it is not part of the original submission at the time we applied to be licensed in a state, but as I testified previously, it is also my understanding and it is our practice to provide these documents to any commissioner's office that requests them from us.
How would the commissioners know to request them from you?
We have ongoing regulatory requirements where we're asked for information by commissioners, either as part of routine audits or in response to other queries.
To your knowledge, has this particular document ever been provided to California's insurance commissioner?
No, I don't know that.
Have you been associated with, or have you been involved with, rather, the responses to inquiries from the insurance commissioner of California?
Assumes facts that there have been such inquiries, but you're free to testify.
It is not my primary responsibility to respond. That is handled by our legal counsel, but periodically I'm asked to provide information in connection with the submission of those responses.
And that legal counsel, is that Mandy Kresny? Is that her name?
Her name is actually Mandy Carey,
Carey.
but she is no longer officially our legal counsel, and in addition, there are many instances where we employ legal counsel who are experts in the specific state that makes the inquiry.
Do you know if, as a matter of practice, this agreement that's marked as 246 is provided to the court along with the power of attorney?
I can't provide that answer to that question specifically, but my understanding is that I don't believe that's the case.
You would agree with me, well, let me ask you this foundationally. Are you familiar with this agreement?
Yes, sir.
Asked and answered? You can answer again.
You've read it thoroughly?
Well, calls for speculation, but you can answer.
Yes, sir, I've read it in the past.
When was the most recent time that you read this paragraph by paragraph?
Don't guess or speculate. If you know, you're free to
You can estimate.
You can do that too.
I don't recall exactly. It's been some period of time.
I'm going to pass you what's been previously marked as Exhibit 237.
Thank you.
If we go to page 3 of 5 of Exhibit 237, do you see at paragraph 10, you have mentioned the contracts that FCS enters with bail companies, including the agreement with BHBB? Do you see that?
Yes, sir.
Paragraph 10. And you state that you have reviewed the agreement with BHBB,
Yes, sir.
and it says attached as Exhibit 6 to the Notice of Lodgement of Exhibits is a copy of the agreement from FCS's files with their confidential financial information redacted.
Yes, sir.
This Exhibit 246, that is the Exhibit 6 mentioned in your declaration, correct?
Yes, sir.
Exhibit 246, was this the first contract that was executed between the McGuires and FCS, to your understanding?
My recall is that there were 2 contracts executed at the same point in time.
What is the other contract?
This contract, as referenced previously, was a retail producer agreement, and then there was also a general agent agreement that was executed at that same time.
All right. And where is the general agent agreement?
Foundation speculation. Where does FCS keep it? Where do you have it? Where do I have it?
Where does FCS keep it?
FCS keeps it in a file at our offices in Houston, Texas.
I need 246.
We have 246.
No, I'm looking in my binder.
Oh, okay.
It's not in my binder.
Do you want me to make a copy for you?
Or just give me that one. Oh wait, what am I talking about? It's right here. It's buried. I have it.
Okay, cool.
The general agency agreement, was that executed at the same time as a retail producer bail bond agreement?
Essentially, that's correct. My recall is that the representatives for DMCG Inc. or Bail Hotline executed both agreements on the same date, and then our representative, the representative for Financial Casualty, also executed them on the same date, but they weren't, everybody didn't sign on the same date.
Sure. It was not all countersigned on the same date.
Misstates testimony.
The general agency agreement, is that still in effect?
Yes, sir.
What is the difference between, what additional information does the general agency agreement have that is not in the retail producer bail bond agreement?
Foundation speculation may call for expert testimony and a legal opinion, but you're certainly free to testify if you have an understanding.
My recall is that the general agency agreement provides for the bail agent to designate what we refer to as subagents, who are licensed agents that are authorized to solicit bail bonds on behalf of that general agent.
Is that the limit of the general agency agreement? Or are there other authorities that are granted?
May call for expert testimony and legal conclusion. You're certainly free to testify as to your understanding if you have one.
I don't recall specifically, but I believe that that's the key difference between the two.
Did you review the documents that were produced to me, to the plaintiffs?
Question's vague and ambiguous. And also, do not reveal any attorney-client communications.
Can you be more specific, please?
FCS, you mentioned that in your declaration, and that is at so Exhibit 237, which I've handed you,
Yes.
that you did a review of books and records, correct?
Yes, sir.
And under your direction, this Exhibit 246 was produced, correct? And
Yes.
you're the president.
I'm sorry, Council.
You're the president.
Can you please state that again?
Under your direction, this was produced, correct?
This being Exhibit 246 for the
Yes.
record. Thank
Yes,
you.
sir.
Did you specifically look at the documents that were handed to me today?
I have not reviewed every single document, no, sir.
Did
There's
you-
thousands of pages.
Did you review any of them?
Yes, sir.
Okay. Can you tell me which ones you reviewed in particular?
I've reviewed the general parameters of what was being provided in response to each production request. The documents were actually compiled by members of our staff.
Okay. Which members of your staff compiled the documents?
Primarily our attorney, Ms. Bays. She coordinated the compilation of all the documents, and a number of our other associates assisted her, people in our various departments, licensing, agent relations, and so forth.
From your review, was the general agency agreement also provided?
My recall is that it was provided.
Does that document that you review from your recollection, which indicates that it was provided, entitled General Agent Bail Bond Agreement?
That's my recall, yes, sir.
Okay. I'm going to pass you what was previously marked by FCS's counsel as Bates number 1320 through 1362. And if you could look at that, tell me where the general agent bail bond agreement begins and ends.
Best evidence.
Well, I don't know. I
May
mean,
call
he's the
for-
one that knows, so how am I supposed to know that?
Best evidence. Document speaks for itself. May call for a legal conclusion and foundation.
It appears to me that the document begins on what is Bates stamped FCS 001320. and ends on what is Bates, the page that is Bates stamped, FCS 001338.
Okay, let's, before you put that aside, why don't you just set it aside so we can make copies of that, because we'll talk about this. Just put it to the side, and yeah, there we go. The next documents, what are they that were directly behind it?
The documents that are Bates stamped FCS 001339 through FCS 001362 appear to include email correspondence between representatives of Bail Hotline and Financial Casualty, and also includes copies of, just blank application and various other forms, statements, and agreements, and authorizations, and other materials that are associated with that process.
All right. If we could go off the record and get a copy of that so we can, this document that he's just looked at, so we can discuss that, that would be great.
Sure, happy to do that.
Off the record, the time is 10:12 a.m.
So Scott, what,
We're back on the record. The time is 10:31 a.m.
Am I losing my mind? Where did I put the general?
I've got one, you've got one?
Okay. Okay, it starts on. Here we go. It starts on 1320.
You got the Bates numbers right, Bill? You get it? All right.
All right, so let's peel off 1320, and we're going to make that Exhibit B.
Just by itself or to the end, Scott?
To 1338.
And I'm sorry, what number are you making this?
1320 to 1338 will be Exhibit B to the deposition.
Let me grab a stapler and/or clips, Scott, because otherwise you know what's going to happen, right?
Yeah, I do.
I think there's some back. Give me 1 second.
That was loud.
Thank you.
Scott, do you want clips instead for you?
Yeah. Okay. So we have that in front of us. Or are we gonna? We'll wait for Tim here.
No, go ahead, Scott, go ahead. You're easy.
Okay. So 1320. That's the journal, which is now marked. We're going to mark that as Exhibit B. What is your understanding as to designating? I mean, why would FCS designate anyone as a general agent when they have already this retail producer bail bond agreement?
May call for a legal conclusion, but you're certainly free to testify to your understanding.
We distinguish a general agent from a retail agent based on whether or not the agent utilizes subagents. And we have clients who are retail agents only. We have clients who are general agents only. And we have clients who are, for lack of a better term, are hybrids, where they have both retail and general agency operations. And that's the reasoning behind utilizing the distinctly identified agreements.
Without going through and comparing the two agreements, can you tell me the difference between them? What one agency agreement provides that the other agency doesn't, and vice versa?
May call for expert testimony, legal conclusion, foundation, but you're free to testify, what you know.
From an operative perspective, the key difference is that general agents will utilize subagents that will potentially be either what are referred to as libel subagents or non-libel subagents. And so when we work with a general agent, we want to identify specifically what those relationships are, solely for the purpose that it's important in terms of responding to any requests from regulators.
Okay. So with respect to the McGuires, who is the general agent for FCS and who are the subagents? Are you able to tell me from this document?
So Scott, just so I understand your question, who at McGuire, one of the McGuire family members, is the general agent in its relationship with FCS?
No, I'm talking about the McGuires and the companies. We have McGuire Bros, we've got Bail Hotline, Bail Bonds Inc., we've got DMCG, and Fugitive Recovery Investigations, Fugitive Recovery International, and the three named McGuire brothers. Who is who from FCS's perspective?
Thank you.
And first, to clarify my answer, I'm going to state who is who based on today, without trying to distinguish at this point all the legal history of the entities. We view our client as being DMCG Inc. They are our bail agent. They do business under the trade name Bail Hotline, Bail Bonds. The principal parties that we work with who are associated with that entity are the McGuire brothers, who are stated as defendants in this case. And that's who we view as being our client for purposes of both the general agent bail bond agreement and the retail producer bail bond agreement. I cannot testify to the specific names of the limited number of subagents that they utilize under the general agent bail bond agreement.
The subagents, are those a different bail bond agent? Do they have separate bail bond agent licensure?
The subagents, of course, have to be licensed bail bond agents.
So would those licensed bail bond agents that your general agent, DMCG, has designated, are those the people that are in the stores writing bail bonds? Is that who that's intended to encompass?
From an operative standpoint, I can't necessarily distinguish it that way, because in the case of Bail Hotline, bail bonds, They are what we would generally refer to primarily as a retail agent because they have many licensed agents that work directly for them. They have, as I understand it, several sub-agents who own their own bail bond agencies and work with them and write bail bonds through them pursuant to our agreement.
Okay, so it's, if I can recap what my understanding is, I understand that DMCG Inc. has its retail stores called Bail Hotline Bail Bonds. And apart from that, DMCG Inc., in its capacity as general agent, has other people, other stores that don't have the bail bond hotline name that are also writing bonds. Is that correct? Am I getting that right?
Misstates testimony. You can answer.
To clarify, I can't testify as to whether the limited number of sub-agents that work with Bail Hotline bail bonds have storefronts. I don't know the answer to that.
Okay.
They are licensed bail agents and they work directly with Bail Hotline bail bonds, but I can't testify as to whether they have storefronts because I don't know the answer to that.
Does Financial Casualty and Surety have bail solicitors in California?
Calls for speculation, but if you understand it, you can answer.
From an operative standpoint, the answer would be no. We only do business with licensed bail agents pursuant to agreements similar to what we're discussing now, but we do not solicit bail bonds from anybody.
Okay. And the insurance code, there's two or three different. It's insurance code 1803. There's a classification of bail solicitor, and then insurance code 1802 is a bail agent. And so California has actually a separate license for somebody who is soliciting. Does Financial Casualty and Surety have any of relationships with licensees under 1803, to your understanding?
You may call for legal conclusion, expert testimony, but you're free to testify what you know.
Based on my understanding, the answer is no. We work directly with agents only.
Okay.
I would speculate.
No. I'm going to instruct you not to speculate. I don't think Mr. McMillan wants you to speculate either.
All right.
Excuse me.
That's okay. The general the general agreement from your understanding, does that allow DMCG to add personnel to sell the bonds as licensed bail agents?
Please clarify.
Well, I understand that you have, let's step back a second. You said that there's some of your agents are operating as retail under the retail producer agreement, correct?
Yes, sir.
And then some of them are acting under the general agency agreement, right?
Yes, sir.
And then another set is operating under both.
Yes, sir.
What would be an example of a company that was just operating under the retail agreement? This what was our retail producer bail agreement, but without the general.
In general, they would not utilize any sub-agents. They would have only their own agents on their own staff writing bail bonds for them.
Okay. And the general agents that don't have a retail producer bail bond agreement, they would not have any agent, or they wouldn't have any staff. Is that the understanding? Is that understanding correct?
Speculation. Misstates testimony, but you can answer, sir.
It's not necessarily whether they have any staff, it's how they solicit or sell bail bonds to insureds. In other words, if they're a general agent, they may do all of their sales through a network of retail agents that they work with under contract. And they may not directly, through their general agency appointment, solicit or sell bail bonds directly to insureds.
Okay.
Most of our agents around the country will either strictly be retail producers, as we would refer to them, or they would be a combination.
Okay.
That would be most likely.
Now, I understand from reviewing the application that Financial Casualty and Surety publishes that there's two sorts of arrangements that Financial Casualty and Surety will work with. One is with a reserve account, and two without a reserve account. Is that correct?
Generally, that's correct.
The reserve account, does the type of agreement, whether it's a general agency or the retail producer agreement, is that related to whether there is a reserve account?
Generally, that is not the case.
In the instances where there is an agreement without a reserve account, what is the bail agent's role in the bonding process?
Generally, the bail agent's role is the same, independent of whether or not a reserve account is maintained.
Okay. For instance, you're familiar with the complaint here. You understand it's regarding the fugitive recovery agents, Wayman, Taylor, and Gorman, correct?
Generally, yes, correct.
When there is no reserve account in the agreement with the bail agent, who is responsible for recovering the fugitives that skip bail?
Foundation speculation. You can answer if you have an understanding. Make also call for legal conclusion. You can answer.
Independent of whether there is or is not a reserve account, recovery is never part of Financial Casualty's responsibility, and it's never part of our arrangement with any customer.
Okay. Well, fugitive, if the agents aren't, or if the defendants are not recovered, what happens with the bond? Financial Casualty and Surety's bond that is posted with the court?
Incomplete hypothetical, vague and ambiguous, calls for speculation. You can answer if you understand it, sir.
Our policy is that the agent is responsible for the bond in all cases, and that is reflected in our agreements.
Okay. Is that policy that the agent is responsible for the bond, is that filed in any place, either with the court or with the insurance commissioner?
As we've stated previously, it's part of our agreement with the agent.
Okay. So if Financial Casualty and Surety does not have a reserve account, how does it enforce its expectation of indemnity from the agent?
May call for a legal conclusion, incomplete hypothetical and expert testimony, but you're certainly free to testify what you understand.
We underwrite insurance, and in part of that process, we're underwriting the credit quality of our agent. Our agents underwrite the credit quality of the insured. Therefore, we are always focused on the credit quality of our agent. And credit quality in our business is like any other financial service business. We're just like a bank or any other lender, in the sense that we are always looking at the credit quality of the primary obligor, which in our case, as provided by our agreements, is our agent. If we were to make a decision not to require a reserve account, it would be because we had the utmost of confidence in the credit quality of our agent. We generally do not waive reserve accounts, but if we do, it would only be for a long-term agent who has demonstrated the quality of their credit standing over an extended period of time.
So essentially, at the outset, regardless of the type of agreement, whether it's a general agency, a retail producer, or a hybrid, everybody is going to have a reserve account and also be expected to indemnify financial casualty and surety. Is that correct?
Not totally correct. It is correct when you state that everybody will be required to indemnify our company. It is not correct that it's an absolute that every agent must have a reserve account. That is a credit decision that is made by our senior management team at our company.
All right. Within the retail producer agreement, let me set that aside. It discusses that, for instance, we look at paragraph 4.
You're on Exhibit 246, Mr. McMillan?
Yes.
Thank you.
At page 1 of 246, it has a paragraph 4, producer's expenses. Producers shall bear any and all expenses incurred in the conduct of producer's business, all expenses incurred by a producer in complying with applicable laws, rules, and regulations promulgated by the jurisdiction in which producer causes company's bail bonds to be posted, as well as all expenses incurred in carrying out company's instructions, directions. The application, my question is, the application of this is that what I'm fathoming here is that everything from advertising for the bond to collecting on the principal that guaranteed the bond if the defendant skips, and paying for the fugitive recovery agents to go and try to capture the defendant that skipped. Financial casualties and surety's intention is that the bail agent bear all of that expense. Is that correct?
Yes, sir, that's correct.
If the bail agent is going to bear all of that expense, why do they need financial casualty and surety?
I may call for expert testimony and a legal conclusion. You're certainly free to testify as your understanding.
My general understanding is that bail is promulgated under statutory authority on a state-by-state basis. And different states utilize different systems of bail. There are states that don't utilize any insurance of any type in connection with bail. There are states that utilize only certain types of insurance that is not consistent with what we provide. The majority of the states, excuse me, accept surety bonds under the type of program that our company offers. And so in that respect, we do business in those states pursuant to the rules promulgated by those specific states. Those states that we do business in do allow licensed bail agents to insure the bonds. In those states, there may be some licensed bail agents that collateralize their bail obligations to the court in other manners, utilizing other forms of collateral. But in those states that accept bail surety insurance, what we do tends to be the methodology that is most prominently used.
Thank you. Now, what happens if have you ever had a bail agent that went bankrupt?
I believe we have, yes.
Was there any
Forfeitures outstanding for that bail agent that went bankrupt?
Question's vague and ambiguous also exceeds the person most knowledgeable notice. I think we should first establish what jurisdiction we're talking about, if that can even be done, because it may not even be relevant to this case.
Sorry.
Sure. I think we need to establish where this occurred. It may not even be relevant to this case, and it certainly is beyond the scope of the PMK notice. You can answer.
I can't recall specifically whether that has been the case, but I guess it could be.
Don't guess or speculate, sir.
Has financial casualty and surety ever had to pay on a forfeiture?
You're talking about in California,
Anywhere?
beyond the scope of the notice, also irrelevant to these proceedings. You can answer.
My recall is that we have not had to pay on a forfeiture in California.
How about elsewhere?
I don't recall.
Is it your understanding that a financial casualty and surety would be expected to pay on as the primary obligee on a forfeiture in California in light of its issuance of a bond?
Incomplete hypothetical may call for expert testimony and a legal opinion. You're free to testify if you understand it.
I believe so.
Do you know if there are any documents that suggest to the court that your bail agents will be responsible for paying rather than financial casualty and surety?
And again, Scott, are we limited to California or just company-wide?
California.
Okay, thank you.
I can't answer the question from a legal perspective, but I believe that the courts understand that the licensed bail agents are obligors on the bonds.
The agents or the surety?
I believe that the courts understand that both the bail agents and the sureties are obligors on the bonds.
Why do you have that? What is it? Where did you get that belief from?
I'm not expressing a legal opinion. I'm stating that from an operative perspective, it's my understanding that the courts notify the bail agents if there is a problem or an issue with a defendant who is insured.
Okay. You're generally familiar with, at least as far as surety, with significance of being someone's agent or having an agent
May call
in
for, sorry,
a bail relation, or in a agency principal relationship, correct?
calls for legal conclusion, expert testimony, vague and ambiguous. If you understand it, you're free to testify, but I'd caution you.
Based on my 30-plus years of experience in insurance, it's common for insurance companies, including sureties, to contract with agents.
Good. And allow those agents, in the exercise of their power of attorney, or their general agency, or their limited agency, to bind the principal, correct?
Calls for expert testimony, legal conclusion. You're free to testify if you understand the question.
In the property and casualty insurance industry, underwriters, which are briefly defined as insurance companies, reinsurance companies, traditionally do assign underwriting authority to agents.
And essentially, that's what's happening here. The financial casualty and surety is assigning underwriting authority to bail agents such as DMCG and the McGuire brothers. Is that fair?
Yes, sir, that's correct.
And financial casualty and surety understands that if it is primarily liable on its bond that were underwritten, even if those bonds were underwritten by its agent. Is that fair?
Incomplete hypothetical, vague and ambiguous, calls for speculation and expert testimony, perhaps a legal conclusion. If you understand it, you're free to testify.
If our agent, our bail agent, is assigned underwriting authority pursuant to an agreement, then yes, we understand that we are obligated on those bonds.
Okay. And the bonds that have been issued by the McGuire brothers and DMCG since 2009, which identify financial casualty and surety as surety, financial casualty and surety is obligated to pay those bond amounts if the legal conditions are met, correct?
Incomplete hypothetical, vague and ambiguous, speculation may call for a legal conclusion, expert testimony. You're free to testify if you have an understanding.
Yes, sir, that is my understanding.
That's the whole purpose of a bail bond, right?
Yes, sir, that's my understanding.
Because the court wants somebody that's identified as having financial resources that will be held to account if the defendant does not appear. Is that fair?
Yes, sir, that's a fair conclusion.
Okay. Now, had you ever heard, before you saw this lawsuit, had you ever heard of any of the plaintiffs?
I had not personally ever heard of Mr. Taylor, Mr. Gorman, or Mr. Wayman. That is correct.
Actually, before the case was filed, you weren't, at the time of the filing of the case, you weren't employed, but by, you weren't president, and you weren't actually employed as an employee of financial casualty and surety specifically, correct?
Yes, sir, that's correct.
But you were a director.
Yes, sir, that's correct.
And you never heard their names come up at any of the board meetings? Correct?
No, sir, I did not.
Yeah. How about fugitive recovery agents? Had you heard that term before?
You mean just generally and
Generally.
Okay.
No, sir, I had not.
How about bounty hunters?
Generally, I had heard that term before.
Had you heard it in in connection with the surety business?
No, sir, I've heard the term on television.
From your understanding, and as the person most knowledgeable for financial casualty and surety, was financial casualty and surety aware that sometimes the defendants did not show up for their hearing and had to be captured?
I think in general we understand that that can happen, yes.
Did they understand that there were people that would go out and hunt for these defendants?
Yes, sir, I think so.
Was that the expectation of financial casualty and surety, that those defendants be captured and brought to justice, as it were?
Assumes facts, vague and ambiguous speculation, but you can answer if you know.
Not specifically, no.
Well, financial casualty and surety risk the forfeiture of the bond if those defendants weren't captured, right?
The company understands that there's always a risk of forfeiture, whether it involves whatever it may involve. We understand that. That's the business that we're in. That's the risk that we insure. But we've never been involved in or taken any initiative to be involved in, the responsibilities of the bail agents.
Does financial casualty and surety require that its bail agents provide a forfeiture avoidance plan?
Question assumes facts, vague and ambiguous. They call for legal conclusion, but you can testify if you have an understanding.
Can you clarify a forfeiture avoidance plan?
It's something that I believe that I saw on Financial Casualty and Surety's website, or maybe it was on the forms application for a bail agent, that there was a mention of a forfeiture avoidance.
I don't recall that, but I can testify I've never discussed or proposed or presented or recommended any type of forfeiture avoidance plan.
Okay. As part of the application process or as part of the compliance process for the bail agents, are they required to
Make any sort of reporting on what they're doing to avoid forfeitures?
To my knowledge, not specifically. What we focus on is overall underwriting and credit.
From your understanding, does the bail agents such as DMCG and its affiliates, do they provide reports on what forfeitures are threatened in the courts for the failure of the defendant to not appear?
Yes, they do.
And how does that reporting take place?
The bail agent provides a report of, pending bonds that are potentially subject to forfeiture or have been exonerated.
Why does financial casualty and surety want that information?
Assumes facts, but you can answer.
We require that information to maintain complete records on our bonds and provide information to regulatory authorities if they ask for information about any specific bond that we issue.
Okay. And you're familiar with seeing those reports, correct?
You've seen
Yes,
those
sir.
reports.
Yes, sir.
I'm going to mark as Exhibit C. Here you go. Here. I'll pass that back, please.
Well, this is C.
Yeah. Oh, that's B. Okay.
Yeah.
Yeah. So you have an Exhibit C already, or?
That goes on here. Let's take these out of the way and keep them organized. Give me 1 second, Scott, so you stay organized.
We've been trying.
Thank you.
There's a C for you.
Now we have a C. All right. Give me 1 second, Scott.
This really kind of makes sense.
We'll keep those organized for the court reporter. She'll appreciate that.
Okay. Well, that's one I'm getting ready to look at.
Yeah.
Okay.
All right, thank you, Scott.
You're welcome. Did I give you a?
Yeah, I have one. I'm good.
Okay.
Rolando, you need Rolando might need one. This is C, right?
Yes.
Thank you.
Lisa M. Hernandez. She works for you, right?
Yes, sir. She works for our company.
Okay. And does she work in the same office as you?
Yes, she does.
Okay. Do you know her?
Yes, I do.
And she been there the entire year that you were there?
Oh, she's been there for a number of years.
I just handed you Exhibit C, which is FCS 0000444, and it's entitled, the subject is, it's an email with the subject Ray, California, CA, 2 large bonds total $240K, left paren, bail hotline, right paren. You agree with me?
Yes,
That's
sir.
what it says. It says, update, Gallegos Carlos, file has been given to our recovery team for apprehension. Do you know what they were referring to when they said recovery team? It's Jennifer Velez, I guess, was the sender.
Not specifically, no.
This Lisa Hernandez, it says that she's a forfeiture associate.
Yes, sir.
What does a forfeiture associate do?
That position, there's several that work in that position. They obtain information from our bail agents regarding the status of bonds that potentially could be forfeited or more likely will be exonerated. This is necessary to maintain the accuracy of our bond inventory and the associated files.
So you have some sort of inventory list of all of the bonds outstanding?
Well, we have to maintain a list of every bond that we issue or that is spoiled or lost.
Why?
That's correct. It's required by the state regulators.
The state regulators for California or for Texas or where?
For any state that we're licensed in.
Who owns FCS?
FCNS is owned by the Steves family in Houston.
The Steves family?
Yes, sir.
That's spelled S-T-E-V-E-S?
Yes, sir.
Do they have other surety companies?
Foundations.
No, sir.
How long has FCS been in business? FCNS?
Actively in business for over 15 years.
Do they have to have reinsurance? Do they use reinsurance?
We do not utilize reinsurance for the bail bond underwriting.
So do they have to have a certain amount of capital in place to qualify as a bail bond surety for California?
Yes, sir.
And do you know what that capital amount is?
Yes, sir.
What is it?
$10 million.
Okay. If we go back to
46. I'd like you to look at paragraph 9, which is on page 3. It says, producer's duties with regard to bond administration. Producer will be solely responsible for it and its employees and/or independent contractors satisfying bail bond forfeitures, semicolon, investigation of bail bond principles and prospective bail bond principles, semicolon, negotiation, settlement, and/or satisfaction of claims against company and/or producer by all bail bond principals, comma, courts, comma, and/or others, semicolon, and/or any and all other matters of bail bond administration hereunder, period. By producer, that, in this case, it would be DMCG or one of the other McGuire brother affiliate entities, correct?
Yes, it would be our bail bond agent in this case.
And the bail bond principals, who would that be?
It would be the authorized parties for the bail bond agent, and the use of that term is provided that way because it is possible that those individual parties may change over the course or lifetime of a contractual arrangement.
I'm sorry, who is it? Bail bond principals?
It's the authorized representatives for the bail bond agent.
Are you sure that that's not the person that's signing on the bond to get the defendant out?
Foundation, speculation,
I'm
legal.
not sure I understand your question.
Okay. Find a form here. Let me see the regulatory filing there. Wasn't there a regulatory filing that I got?
You thinking of this one?
301 is what I'm looking for.
301.
Yeah, let's move all of the exhibits over here in front.
That one?
Yeah, court reporter. Yeah.
That's 301.
Okay, so 301, we have these forms. You've seen this form before, right?
Yes, sir.
Is this the application? And we're looking at what page there?
It's page 25 of 40 is how it's listed.
Okay. And that's 301, on Exhibit 301.
Yes, sir.
The indemnity, if you go down to the bottom of the page, Is that the bail bond principle? It's 2/3 down.
No, sir, I don't believe so.
Okay. Is the defendant the bail bond principal?
That's not my understanding, no.
So on paragraph 9, if we're going back to Exhibit 246, it refers to the producer. It refers to bail bond principles. It refers to the company. You see that?
Yes, sir.
So the producer is who
Asked and answered, you can answer it again.
under this contract?
Asked and answered, you can answer it again.
As I've stated previously, under this contract, the current producer is DMCG Inc.
Okay. Do you have is there a new version of this contract that reflects DMCG as a contracting party?
Question's vague and ambiguous, you can answer.
I don't believe so. I believe that DMCG standing as the legal party was added by addendum that's contained within these documents.
Okay. But you see where it says here at the very front of this exhibit, 246, that Daniel McGuire and/or the bail hotline bail bonds is designated as the producer, and now that would be substituted for DMCG. Marco A. McGuire and/or Gilbert McGuire and/or Maritza McGuire and/or Caesar McGuire and/or Zolma McGuire, those are the producer indemnitors.
Yes, sir.
Then we have people that are in paragraph 9 that are identified as bail bond principals.
Yes, sir.
And your understanding as to the bail bond principles is that they are who?
Asked and answered, you can answer it again.
I'm not sure of the legal interpretation.
Okay. So you see there's an investigation of bail bond principles and prospective bail bond principles. So that would suggest that there was somebody that was off in the future that FCNS and the McGuires haven't identified yet.
Misstates,
Would you agree with me?
misstates the document, argumentative, asked and answered.
I'm not sure. I can't answer that question.
Okay. The bail bond administration, it's foreseeable to financial casualty and surety that there is going to be a need to investigate the people that it's giving bonds on, right?
Please clarify.
They need to, before they go and issue a $100,000 bond on some member of the cartel, they need to make sure, or alleged member of a cartel, they need to make sure that there's somebody that is going to pay for that, indemnify the company if this alleged criminal doesn't appear for court, right?
May call for legal conclusion,
To
speculation.
clarify, when you say they, do you mean financial casualty? Or do you mean the bail bond agent?
No, excluding the bail bond agent. The financial casualty and surety understands that criminals, alleged criminals, often do not have credit, correct?
Foundation speculation.
We don't believe that in most cases that credit decisions that are made by our bail agents who have underwriting authority are based on credit standing of the defendant. They're usually based on credit standing of the indemnitors.
Okay. So in this contract, could it be possible that the bail bond principles that are mentioned in paragraph 9 are either going to be the indemnitors or the defendants?
Misstates the document, foundation, a legal conclusion.
I don't believe so.
Okay. It suggests by paragraph 9 that financial casualty and surety expected that there would be legal motions to preserve, reinstate bonds that were written by the bail agents. Would you agree with that?
Were you referring to, counsel, in paragraph 9?
It's mid-paragraph. The words preserve, reinstate, and exonerate bonds.
My interpretation of that particular sentence in paragraph 9 would be that we are communicating and wanting to make sure it is exceptionally clear that any expense associated with those processes are the producer's sole responsibility.
But my question is a little bit different. At the time that it drafted this contract, financial casualty and surety understood that sometimes there's legal proceedings to preserve, reinstate, and exonerate bonds associated with bail bonds, correct?
Foundation speculation. You can answer.
I'm sorry,
Foundation speculation, you can answer.
I don't specifically know the answer, but I understand that that would be a potential interpretation.
Okay, and that is a risk that of doing business in the surety and the bail bond business is someone's going to have to go to court to preserve, reinstate, and exonerate bonds, right?
Yes, sir, that's correct.
And it's like also a risk in the bail bond business that fugitives are going to rabbit.
Questions vague and ambiguous.
Defendants are going to rabbit,
Questions
correct?
vague and ambiguous speculation.
Please clarify what rabbit means.
Abscond, try to run.
Yes, we understand that there are situations where insurers may try to avoid appearing in court.
But the whole purpose of the bond is that they get out if someone else is going to essentially take a bet that they will come back, right? An insured risk.
Well, the foundation of the system of bail bonds is to provide the defendant with the maximum opportunity to defend themselves against the charges.
Okay.
Okay, and with respect to when there are actual forfeitures that are threatened, forfeitures of the bond, financial casualty and surety receives notices from at least the California Superior Court, correct?
Yes, sir, that's correct.
And financial casualty and surety also receives notices from its bail agents, correct? Such as
Yes, sir, that's correct.
DMCG. DMCG and the McGuires are expected to inform financial casualty and surety when a forfeiture is threatened, correct?
Yes, sir.
And financial casualty and surety, from the appearances of this contract, expects that DMCG and the McGuires are going to take care of that problem of a threatened forfeiture. Is that fair?
Not exactly the way I would characterize it.
How would you characterize it?
The purpose of the contract is to clarify the responsible party to address that type of a situation, to clarify who the responsible parties are that are obligated for that, and is meant to protect our interest in terms of meeting our reporting obligations to both regulatory authorities and any other interested third parties.
But if you didn't have this contract and this specific provision in here, DMCG, if somebody left, they could simply say, well, we're really sorry about the loss that you've suffered as a result of our poor underwriting decision, but it's not our problem. True?
Vague, ambiguous, incomplete, hypothetical, may call for a legal conclusion.
No, I don't agree with that. We make it very clear what their obligations are.
Okay. But if there weren't any of these statements in the contract, this contract alone, DMCG would be in a contractual position to not have to indemnify financial casualty and surety absent some sort of gross negligence. Is that fair?
Incomplete, hypothetical, calls for legal conclusion. Vague and ambiguous, speculation.
I can't provide any legal opinions, but without this contract, there'd be no relationship and there'd be nothing at issue.
Well, this contract isn't what the courts know about, though. The courts know about your power of attorney, correct?
Asked and answered.
And that's a separate matter from this contract. True?
Vague, ambiguous, compound, speculation.
We won't issue powers of attorney to anybody without having an appropriate contract.
Okay, if we can look at the next page. And, well, actually, it starts on the bottom of well, let's complete paragraph 9 here. Paragraph 9 has some expectations from the company that the producer, which in this case is DMCG, is going to update with court stamp copies of any and all motions for appeal or forfeiture immediately upon filing of the motion, right?
Yes, sir.
Okay. Now, in California, financial casualty and surety, it appears through its attorneys in court, correct?
Please clarify with regard to what matter.
Sure. Well, let's back up a little bit. Financial casualty and surety receives regularly in the course of its operations correspondence from California indicating that bonds are subject to forfeiture, correct?
Yes, sir, that's correct.
And once that happens, financial casualty and surety will make an appearance in court, correct? In California.
My understanding is that an authorized party will appear on behalf of financial casualty and surety. That's my understanding.
By authorized party, do you mean someone from the McGuire brothers or an attorney for financial casualty and surety?
The McGuires will be responsible for appointing an authorized party or attorney to make the requisite appearance in court.
And so they'll appoint the attorney, but will they appoint the attorney for financial casualty and surety, or will they appoint the attorney for themselves?
Question's vague.
I can't express a legal conclusion, but I would interpret it as they're appointing an attorney to represent the interest of both parties.
Okay. has Financial Casualty and Surety authorized McGuire Brothers to hire attorneys on its behalf?
I believe so.
Hang on, you mean just ever in general?
Yes.
I'll stipulate that I've been hired by FCS.
No, I asked if McGuire Brothers have been authorized to hire attorneys for FCS.
Specifically with regard to the bail bonds that we issue?
Yes.
They call for a legal conclusion, incomplete hypothetical.
I believe the contract is clear on what's provided in that regard.
Okay. Do you know if the McGuire Brothers have actually hired attorneys to appear on behalf of FCNS regarding bail bond forfeitures
In California,
in California?
foundation
I believe
speculation.
so.
And FCS was fine with that, correct?
Foundation speculation.
I'm not certain of the legal answer, but I believe so.
They didn't object to it, saying, no, this is, FCS will seek out its own legal counsel rather than you hiring its attorneys.
That is customary with our business, yes.
You let the bail agents hire an attorney for the Financial Casualty and Surety.
In general, that is part of the responsibility and authority of the licensed and authorized bail agent.
Okay. Let me see this. What's our time there, Tim?
11:36, we've been going for a little over an hour. What's your plan for lunch? Could we go off the record for a second?
Sure.
Off the record, the time is 11:36 a.m.
What's your plan for luncheon today?
Back on the record, the time is 11:53 a.m.
Okay, I'm going to pass you Exhibit 202.
Thanks, Scott.
202, that's an example of a pleading that would be filed in the ordinary course of Financial Casualty's business, correct? Come in.
I'm not familiar with this specific document before today, but I understand in general that this would be a motion that was filed on behalf of our company to set aside a summary judgment.
Okay. Have you seen motions like that in the past?
I've seen motions in the files, et cetera. Haven't dealt with any specific case, but I know that we do have some documentation that comes into our files, and we have that information.
Okay, because under find that exhibit again. 246. That was our contract, I think. Correct? Under 246, that's you receiving notice, FCS
receiving notice would be a requirement. It would be required for DMCG to send FCS these notices such as this, correct? Like 202.
Yes, I believe that's correct.
And do you know who hires John M. Rorabow, or who hired him on behalf of Financial Casualty and Surety?
I don't personally know who hired him, but I would assume, based on my general understanding of operations, that the attorney would have been hired by DMCG.
And DMCG, as Financial Casualty and Surety's agent, would direct the attorney as to what the objectives were in that case, to set aside the forfeiture, or, correct?
Calls for legal conclusion, speculation, and complete hypothetical.
It's my understanding as the company's authorized bail agent that is their responsibility. They would direct any actions to be taken by counsel.
Okay. Do you know if Financial Casualty and Surety ever has allowed the DMCG or the bail hotline or the McGuire brothers to hold themselves out as Financial Casualty and Surety?
I understand that our contract prohibits it, and I don't believe that they've ever done that. So I don't think that's happened, no.
Okay. And for reference sake, I provided you Exhibit 202, which is case number 37, 2016, 0026379, a filing of September 8, 2016. I'm going to pass you another document that's 204, and that's from a Matthew Singer. Have you ever heard of Matthew Singer?
No, I don't believe I've ever met or know Matthew Singer.
If you look at the document there, it's the same case for the forfeiture of the bail bond. Now, Mr. Singer, or whoever drafted this, let's see whose name is it on, he actually refers to Financial Casualty Insurance and refers to it as bail agent. You see that?
I'm looking at page 3 of 47, and I'm a little puzzled because, to state the obvious, I don't know what CASULTY even spells, but and it doesn't make any reference to our name as it is properly constituted, so I'm not sure what was trying to be accomplished here.
Okay. If we go to Exhibit 204, page 33, would you turn to 204, page 33?
I'm sorry, what page, counsel?
It's Exhibit 204,
Yep.
page 33.
Thank you.
You're welcome. You see, that's a case that Financial Casualty and Surety was had written the bond on.
Yes, sir.
Okay. And if you look at page 21 of that same Exhibit 204, We have Mr. Singer, the attorney, saying he's attorney for real party and interest, bail hotline, bail bonds / financial casualty and surety. Looks like he spelled it right that time. See that?
You're talking about in the caption or in the body on line 24 where he talks about bail agent?
And the line 5,
Line 5, okay.
real party and interest, bail hotline, bail bonds, financial casualty and surety.
Still not correct.
Right.
Still not correctly states our company.
Right? And then he signs for it, attorney for real party and interest on the next page, on page 22, financial casualty and surety.
Well, he signs for that entity, whoever that entity is, counsel.
Well, he signs for financial casualty and surety.
Right. We don't know that entity. He's not here as the person most knowledgeable for an entity called Financial Casualty and Surety.
Who is he here for?
Well, you can ask him that.
Are you pointing out that the ink is left off?
Among other things. I think the record will reflect what it is, but go ahead.
Have you allowed bail hotlines, bail bonds, or DMCG to use financial casualty as a DBA?
Not to my knowledge, no.
Okay. Have you ever met Matthew Singer?
No, sir.
And if we go to the end of 204, let's go to page 46. We have the summary judgment order. See that?
Yes, sir.
And that's something that type of order is something that you expect to be received, be given notice of, both by the courts and by DMCG, correct?
Foundation, speculation, assumes facts.
My understanding is we expect to give a notice of a summary judgment such as this by the court, yes.
Okay. Would these documents are regularly sent to financial casualty and surety in the course of your bail agents, particularly these bail agents, DMCG and McGuire, part of their compliance under the contract, right?
Can you read back that question, please, Madam Reporter? Because I think you've misstated something, counsel. I want to make sure that wasn't, if it was intentional, great, but if it's not, I don't think that's what you were intending. But let's have the question read back.
These documents are regularly sent to financial casualty and surety in the course of your bail agents, the bail agent DMCG and McGuire, as part of their compliance under the contract, right?
And you're saying these documents, the ones, Exhibit 204?
Sure, and documents like it.
Okay. Go ahead. I think that's been asked and answered, but you can answer it again.
I believe that these documents are sent to us to allow us to meet our, reporting obligations.
Okay. If we go to page 34 of Exhibit 204. See, there's a declaration of bail fugitive recovery agent Robert Connolly.
It seems to state declaration of fugitive recovery agent Robert Connolly.
Okay. Have you seen similar declarations from fugitive recovery agents in the past?
Question's vague and ambiguous.
Not that I recall, no.
Were you aware that, well, let me put it this way. If we look at this, Exhibit 204, Mr. Connolly describes page 35, two-thirds of the way down, on April 27, 2016, various searches were completed in several criminal and background databases in an attempt to acquire new leads, as well as verifying the defendant was not currently in custody. You see that?
Yes, sir.
Okay. Is that the type of information that you understand would be done in the performance of the bail agent's job,
Question's vague and ambiguous, calls for speculation. You can answer.
those efforts?
Same objections.
I understand that maybe they do something like this, but I don't have any details on it because it's just not something that we deal with or, quite frankly, have any concern about dealing with.
Have you seen similar declarations in the past from fugitive recovery agents describing the efforts they had made to locate people?
No, I don't recall seeing any.
Excuse me. All right. Okay, you also provided the oppositions, correct? The county council's opposition to the forfeiture of your bond as a normal course of the business.
I'm sorry, Counsel. The question's vague and ambiguous.
Please clarify.
Well, for instance, I'm going to pass you Exhibit 207, which corresponds to the first exhibit that I gave you, which is 202, I believe. Exhibit 202, that corresponds to 202.
Do you have a copy?
Yeah.
Thank you.
Okay, see, that's the opposition to 202. Are you provided, is FCNS provided the oppositions to the forfeitures as well?
I am not personally provided these, so I can't say that we are. I don't know the answer with certainty.
In reviewing the records before you came to testify here today and the documents that were produced, you saw some court dockets, right? There's printouts from court dockets in there, in the documents that were handed to me in the morning. Did you see
Yes.
those as well?
Yes, yes.
Okay. All right. Did we attach the general agreement as an exhibit? It would have been one of the clipped ones.
I think it was C as in Charlie. I stand corrected. It's B as in boy.
Okay, that's the general one.
If
Okay,
that's-
very good. Very good. Thank you. All right.
Now, within the documents that were filed, and if we can see that document, the first one that I showed you, the statement. My memory fails me on this, what the number was. It's the regulatory file.
Exhibit 301.
That's 301. If we look at 301, and we go to page 40 of 301.
Last page.
Yeah. Would you tell me what that document is?
It's titled Authorization to Arrest Defendant on Bail Bond.
Why is Financial Casualty and Surety filing this with the California Department of Insurance?
They call for legal conclusion, vague and ambiguous.
I'm not sure if I'm qualified to answer. I believe just from reading it that it's just providing an authorization on our behalf to, arrest a defendant.
And Financial Casualty and Surety, did it intend that actually some defendants that did not appear for their bond hearing, make their appearance according to the court order, actually be arrested?
I don't really know the answer to your question, but I believe that it's us giving authorization to, an authorized party to perform that on behalf of our interests, yes.
And does Financial Casualty and Surety intend that defendants that don't show up for court be arrested according to this form or some similar form that it provides?
They call for legal conclusion, foundation, and speculation. You can answer.
I believe we're providing authorization for our bail agent to perform that service, yes.
Okay. And Financial Casualty and Surety authorized the bail agents to put Financial Casualty and Surety's name on these authorization to arrest defendant on bail bond, right?
Misstates the evidence, misstates the document. You can answer.
I believe I've already testified that, yes, I believe that's our authorization.
Okay. But it was okay for the bail agents, whoever they are, to go ahead and issue those in your name, right?
Yes, I believe so.
Did you review the complaint in this case? The second amended complaint?
I don't believe so.
Okay, I'm going to pass your Exhibit 215. It's the actual complaint.
Thank you.
Copy. Okay, if you go to, find the page on my side here. If you go to page 64, the 64th page of Exhibit 215. Was this affidavit signed by Financial Casualty and Surety, or by the bail agent, excuse me, let me strike that. Page 64 of 113. It's entitled Affidavit of Undertaking for Bail for Surrender of Defendant pursuant to Penal Code Section 1300, left paren A, right paren, left paren 1, right paren. It's executed by Martin Delgado. It says Surety Company, Financial Casualty and Surety Company, Inc. Did Mr. Delgado have authority to execute this document?
I call for a legal conclusion, foundation, and speculation. You can answer.
My understanding is that DCMG would have had authority to sign this document. And so that's all I know with certainty.
Okay. But sign it as on behalf, acting as agent for Financial Casualty and Surety.
Foundation, speculation may call for a legal conclusion.
I believe so.
If we go to Exhibit 215, page 65, that's one of Financial Casualty and Surety's bonds.
It appears to be, yes.
What happened to Mr. Sabo?
What do you mean?
Is he still, did he retire or something?
Yes, sir.
You see that he signed the form. It says signature on the bond.
Yes, sir.
Did he have the authority to sign bonds for Financial Casualty and Surety?
At the time this bond was issued, he did.
When did his authority to sign bonds on behalf of Financial Casualty and Surety end?
I don't recall the exact date, but it would have been about the time that we started talking about his retirement.
As part of the reporting requirements of DMCG under either the producer agreement or the general agent agreement, is DMCG required to give Financial Casualty and Surety a copy of the affidavits of undertaking?
I can't recall the answer to that. I don't know the answer to that specifically.
Do you remember seeing the affidavits of undertaking when you went through the documents in order to comply with the request for production?
I don't recall seeing them, no.
Have you ever seen an affidavit of undertaking of bail for surrender of defendant before coming here today to this deposition?
I don't recall specifically seeing one, but there were a lot of pages, and I went through them fairly quickly.
Okay. Is the term affidavit of undertaking of bail for surrender of defendant, does that sound familiar to you, or is that not something that you've heard of before?
It's not familiar to me. Defining familiar as being something I've dealt with regularly, no.
Okay. And the execution of an affidavit of undertaking of bail for surrender of defendant pursuant to Penal Code Section 1300A1, such as that on Exhibit 215 at page 64, that's not a deviation from what you would expect
the bail agents to do in the course and scope of their agency, correct?
Foundation speculation may call for a legal conclusion.
I don't feel qualified to answer that question because this is a legal document. So I prefer not to. I don't honestly know.
Do you know what the result is? What this is? What this has the effect of?
May call for legal conclusion, expert testimony, foundation.
No, because I'm not familiar with Section 1300A1.
Okay. We actually have a... I have a copy of 1300A1 there. If you could read that aloud.
Well, we'll stipulate, counsel, if you're making a representation that this is what the statute says as an officer of the court, we'll stipulate that that's what it says.
That's what it says.
Okay. Question?
Has he read it?
Yes, I read it.
Pass that back to me. That's my only copy. Okay. 1300A1 reads, a certified copy of the undertaking of the bail, a certified copy of the certificate of deposit where a deposit is made, or an affidavit given by the bail licensee or surety company listing all that specific information that would be included on a certified copy of an undertaking of bail must be delivered to the officer who must detain the defendant in his custody thereon as upon a commitment and by a certificate in writing acknowledge the surrender. Are you familiar with that process where there's essentially an affidavit that's written by the surety or the bail bondsman, and they go out and they grab the defendant and then take them to jail?
Hang on, counsel. I think you should have the court reporter read that back because I think you may have misspoke. Maybe it's intentional. Can you read that back, please?
Okay, 1300A1 reads, a certified copy. Question?
Just the question. We don't need to read the statute. I think we all agree what the statute says.
Are you familiar with that process where there's essentially an affidavit that's written by the surety or the bail bondsman, and they go out and they go after defendant and then take them to jail?
Okay. Do you really? Okay. So the question is compound. It misstates the evidence, mischaracterizes what the statute requires. It's argumentative. It's misleading. I'd caution you.
Okay. Do you understand that? That bail, the fugitive recovery or bounty hunter or person has to have a document to allow them to go out and take this person into custody, this defendant who skipped on bail.
I'm not familiar with it, no. But based on the reading of the statute, I think I understand what the statute is saying.
Okay. And that would be consistent with what you would expect, that there would need to be some documents that would authorize someone to go grab somebody else and take them to a cop,
Hang
right?
on. Questions and incomplete, hypothetical, vague, and ambiguous.
I honestly don't know. I've never dealt with anything involving recovery. I don't know anything about recovery. I've never been involved with recovery. We don't get involved with recovery. I don't want to sit here and try and tell you that I know or I have knowledge or expertise on this because I don't. I can read a document and try to interpret what it says just as a layman, but no, I don't have any expertise on this.
Okay. But would you agree with me
Mr. Shields, that the document that we looked at that was filed with the state of California, at Exhibit 301, page 40, if you want to open that up. It's right on the top there.
Right.
The last page of it. Those satisfy the same functions.
Questions vague and ambiguous, calls for speculation and legal conclusion. Foundation.
I may be repeating myself. With regard to page 40 of Exhibit 301, I testified previously that I do believe that this is a document in which my company intends to give authority to our bail agent for purposes of this process.
Okay. And the bail agent,
Would that be DMCG, or is the authority being given to a specific person to effect an arrest?
Incomplete hypothetical. Vague and ambiguous, calls for speculation.
I'm probably not qualified, but I believe that our intent is to give the authority to our authorized bail agent, which I'm defining as DMCG Inc.
okay. Was it outside the scope of DMCG Inc.'s authority to tell Ken Gorman, Nicholas Wayman, and Will Taylor to go and capture Brooke Nicole Childs
For failing to appear on bond?
Foundation speculation. It's also beyond the scope of the PMK notice. He's not here to talk about what DMC's policies and procedures are. He's here to talk about FCS policies and procedures. So I think the question's beyond the scope.
No, I'm asking about whether it was outside of the scope of FCS's authority that Ken Gorman, Nicholas Wayman, and Will Taylor would go and seize Brooke Nicole Childs for not appearing on financial casualty and surety's bond.
Foundation speculation. Incomplete hypothetical. Legal conclusion. You can answer if you understand it.
I believe I understand your question, but I don't know the answer. I mean, you're asking me a legal question that I don't know the answer to.
Do you expect, as the president of financial casualty and surety, that the bail agents are going to be going out themselves in the middle of the night and grabbing these defendants that haven't appeared on bond?
Incomplete.
Or will they do that, will they delegate that off to somebody else?
Incomplete hypothetical. Foundation speculation.
Our intention is to provide our authorized bail agents with the ability to manage their business as they see fit. That's really all I can say.
Well, my question is a little bit finer than that. My question is, we now agree that the bail agents had the authority to execute affidavits,
Basically, arrest warrants, if we can use a broad term. They had that authority from financial casualty and surety to execute those in financial casualty and surety's name, correct?
Questions vague and ambiguous, calls for legal conclusion.
I'm sorry, I just can't answer the legal question here. It's beyond.
It's not a legal question. It's whether financial casualty and surety gave its bail agents the right to delegate
The arrests of these defendants did not appear on bond.
Calls for a legal conclusion. Speculation. Incomplete hypothetical. Vague and ambiguous.
As I testified previously, we gave the authorization to DMCG. I can't speak to what DMCG authorized other parties to do on their behalf. That would be speculative on my part. And that's not contemplated under our agreement. We gave them the legal authority to represent this bond.
Mark that, please, Madam Reporter.
Don't do that. You know that that's improper. Did you give them the legal authority to delegate to third parties?
Question's been asked and answered. If you have something different, you're free to testify. Question as phrased is vague, ambiguous, incomplete, hypothetical, calls for a legal conclusion.
I just don't have any other answer. I don't have
It's a
more
yes or no.
information.
No, we didn't tell them to delegate. They had to do it themselves.
Is that a question, counsel?
I mean, it's either one way or the other.
Is
That's
it-
how I'm seeing this, Mr. Shields. Did they delegate it or not?
Asked
Is it
and
delegable?
Asked and answered, calls for a legal conclusion. Foundation, speculation, incomplete, hypothetical.
I'll answer your question solely by speaking to the fact of what I'm seeing here, which is they did delegate. But I'm not speaking to whether they should or shouldn't have, because I don't know the answer to that.
Do you expect them to delegate it? Or do you expect them to do it themselves?
To be frank with you, we never had any discussions with them about this. We don't have this discussion with any of our agents. So no, I don't know the answer to that. We don't get involved in recovery. We don't have anything to do with it. So it would be remiss and inappropriate on my part to sit here and say that we do.
Okay. Thank you. All right. Has financial casualty and surety ever directly paid a bounty hunter
In the state of California?
anywhere?
Well, question's overbroad. It's beyond the scope of this litigation. Also, it's beyond the scope of the notice of the deposition. And this gentleman hasn't been designated as
That's
a board.
fine.
You asked for a PMQ on every other state
It's a
outside of
fact.
California.
That's a fact.
That is a fact.
So have they ever paid a bounty hunter direct?
Beyond the scope of the designation and the topics in outline.
Are you instructing them not to answer?
Well, I guess it's beyond the scope, Scott. If you want to narrow it to
No,
California.
no. I want a clear instruction to not answer that question.
It's beyond the scope of the PMK notice, so we'll start with that, and I think that's a proper objection, and
That's fair.
Judge Lewis can rule on that. I don't need to instruct him not to answer. She can rule on that instruction. That's beyond the notice. If you think as an offer to meet and confer, if you think I'm missing something, let me know. But this lawsuit has nothing to do with anything outside of California, so let's start with that. If you want to restrict it
I'm
to
not going to, you guys brought a motion for summary judgment.
in
You're
California.
not claiming that you know what, I'm not going to share what my theories are at this point. If you probably are able to figure them out from listening to my questions. But I'm entitled to answers to my questions unless you instruct them not to answer.
And-
So please instruct them not to answer so we can move on, or tell them to answer. You can answer, you've preserved your objection, one or the other.
I'm just trying to meet and confer with you,
Well, I
Scott.
don't want to meet and confer other records. There's no requirement to do that. So we're wasting time because he has
All
to
right.
get out of here
All
by
right.
4.
All right. I've made my objection. The question pending can go forward. If the witness has a response, go forward.
My testimony is what I can testify to, which is, to my knowledge, I have not authorized the payment of any recovery experts. I'll
Do you know
testify
if
for
that-
myself.
Do you know if that's taken place in the past?
Foundation speculation beyond the scope of the
I don't know.
Okay, that's fine. It's all that, and he doesn't even know. So
Well,
that's,
just trying to protect the record, Scott. You
I
do
know,
the same thing.
Listen, I know. Let's just move on. Let's keep moving here. 'Cause what time do you actually have to leave here? What time is your flight?
A couple minutes after 4.
So you have to be there.
I just got to get there and go through security.
You don't need to check bags or anything?
Now,
Okay.
2:30 probably would be safe. That'll get him there.
Closer to 3. That's fine. This has to be.
I would prefer 2:30 based on the line I saw
All right.
yesterday. Because it was long
All right,
to get
I'll
through
do my
security.
I need some. Do they show up with food?
Oh, no, I thought you wanted to.
No.
You want me to check, Scott? What time did you order? Because if we got stuck in the lunch hour, it could be a little bit longer than usual.
I gave her my card.
All right, let me find out.
When we took our.
You go ahead. Don't wait for me.
All right. Give me 30, starting with.
Probably the next 10 minutes or so, Scott.
Thank you. It's 28. I'm going to show you some more affidavits. Here's Exhibit 28.
Thank you.
You see that that's by Nicholas Wayman, or that is a one that authorized him to make an arrest.
Well, it looks, not to be contentious, Scott, it looks like both Ken Gorman and Nicholas Wayman,
Okay.
but best evidence.
Okay. 29, please. This just makes sense. I'm missing my. Do you know where this chart is?
The chart should be in the front. As an exhibit.
Yeah, my exhibit. You find that, I'll ask you some other questions. Has any of the McGuires had their authority limited since they originally entered into the contract?
Foundation speculation may call for a legal conclusion.
Not to my knowledge.
Okay. Has FCS terminated any of the defendants in this case as their agents?
Oh. It assumes facts that all of the defendants were agents, but he certainly can answer.
Not to my knowledge, no.
Caesar McGuire is an agent, yes.
I know that Mr. McGuire is an officer for DMCG Inc. I don't know his personal agent license status.
mark this as D. Show this to the witness, please.
Thank you. Do you want me to mark it, Scott?
Yes. Does that refresh your recollection as to whether Mr. Caesar McGuire was an agent or is an agent?
Yes, sir, it indicates that he is an agent as of June 21st, 2018.
Okay. Any prior time? Go to the next page.
Yes, it appears that he's also licensed as an agent for financial casualty as a bail agent effective May 20th, 2011, as a PNC broker agent as of June 29th, 2018. And that's it.
Same question for Daniel McGuire. Would you, he's still presently an agent, yes?
That's my understanding, yes. That's correct.
And Caesar McGuire?
We just talked about Caesar D.
Gilberto?
My understanding is that Gilbert McGuire is also a licensed agent.
And Marco?
I'm not certain about Marco McGuire. I don't know.
And is it your understanding that they've been licensed agents since for financial casualty and surety since April 20th, 2009?
When you say they, question's vague and ambiguous.
The whole group, the McGuires, plural.
Each of the McGuire brothers, counsel?
Sure.
Okay.
On or about April 20th, 2009.
If you know, sir.
I don't know with certainty, but I believe so.
Okay.
You would agree with me that giving someone a power of attorney and making them your agent is a pretty serious act of entrustment.
Foundation speculation, vague and ambiguous. You can answer.
We take our responsibilities for appointment of agents very seriously.
What do you do by way of oversight to make certain that these people or entities that you've entrusted to act in financial casualty and surety that has entrusted to act in their name are following the law?
Question's vague and ambiguous when you say these people.
Agents in general.
Bail agents?
Bail agents in general.
Okay.
Our compliance program for bail agents includes monitoring their ongoing reporting, monitoring their meeting their financial obligations, performing periodic audits if necessary of their records. As I've testified previously, it's primarily about, their financial results, because as a surety, we're in the financial service business, and we judge our underwriting performance of our agents based on their results financially.
Is what you're saying that as long as your bail agents are meeting their financial obligations to financial casualty and surety, financial casualty and surety does not pay attention to the manner in which the bail agents are operating the bail agency itself.
Argumentative, misstates testimony.
I guess my thought or comment would be, if we became aware of something that was a concern, I'm sure we would ask about it. But that would not be something that we would routinely go and say, how are you doing? How are you handling this, that, or the other? We're focused on what's important to us, which is we're an insurance underwriter. It's our obligation to protect the interests of our insureds, to make sure that we meet our obligations to them first and foremost. And then as a secondary obligation, we want to generate an appropriate and sufficient return on investment to our capital providers.
And for instance, if in the case of Mr. Taylor or Mr. Gorman, Mr. Wayman, if they see something that's happening that's unlawful, that your agent is, they believe your agent is violating the law, do you have a means by which people can report that?
Vague and ambiguous, incomplete, hypothetical, calls for speculation. You can answer.
I don't believe that it's our company's obligation to require those people in that situation to report that to us. I would like to think that they would be protected by the applicable laws of the state or the federal government, and that if they felt that there was some violation thereof, that they would have the ability to report that and take action.
But you sitting here right now, you're unaware of any obligations imposed by the insurance code or to monitor the conduct of the agents specifically?
Misstates testimony, calls for expert testimony and a legal conclusion.
We really focus
Excuse me, also beyond the notice, but go ahead.
We really focus our compliance on protection of the interest of the insured. That's who our obligation is to our insureds. That's who we focus on.
Who are the insureds?
The insureds are the people that purchase bail bonds.
Okay. So, for instance, if you learned that the McGuire brothers had been paying bribes to people inside Wells Fargo to obtain the insured's account records, that would be of concern to you.
Misstates the evidence in the case, incomplete, hypothetical, vague and ambiguous, calls for speculation.
I don't know how to answer that. I mean,
Well, it would either concern you or it wouldn't.
Questions an incomplete, hypothetical, it's vague and ambiguous, calls for speculation and foundation.
I can't answer that. That has nothing to do with our business.
Okay. And if you learn that that the Sprint, someone inside McGuire's, the McGuire brothers were bribing Sprint employees to provide information or ping phones, which is contrary to California law. Would that concern you as someone, as a company that's interested in protecting the insureds?
Misstates the evidence in the case, vague and ambiguous, calls for speculation and lacks foundation, may call for expert testimony.
I don't think my answer is any different. I mean, we always respond to complaints from our customers. So if one of our insureds made an allegation, regardless of whether we thought it was correct or not correct, if they made an allegation directly to us about something involving their bond, we would look into it.
Does financial casualty and surety have a means for the public to contact it over
We have a
such-
toll-free phone number. We're not hidden. Our name is on every bond. I think that the public would have every opportunity to find us and make contact with us if they chose to do so.
I'm going to pass you Exhibit 214.
Thank you.
Have you ever seen this document before, online or otherwise?
I have not seen this specific one that is published by the California Department of Insurance, but I've seen many documents or flowcharts of a similar nature published by others, yes.
Does this flow chart, is that consistent with your understanding of the bail process?
Yes, sir, it is.
At what point in this flow chart does financial casualty and surety receive information from its bail agent?
Foundation speculation may be beyond the scope of the deposition notice. You can answer.
We generally receive information about the posting of the bond by the bail agent, and we generally receive information about exoneration or discharge. We receive some information about the remainder of the process as part of the file documentation.
Okay. The failure to appear, do you get an alert either directly from the court or from your bail agent that there's been a failure to appear?
Generally, we do not.
Okay. You do certainly get a notification if there's been a forfeiture. True.
Yes, sir, generally we do.
The request for extension or dismissal, did you receive those?
In some cases, yes, but not in all cases.
The summary judgments, did you receive the summary judgments?
Really the same answer. In some cases we do, in some cases we don't.
I assume civil process, it gets cut off before it gets to civil process, right?
Foundation speculation.
You don't get notices of levy, right?
No, sir, not typically.
Have you ever gotten a instruction from the court that money needs to be tendered or the bond will be taken?
Generally, our agent notifies us of that before we would get any notification from a court.
So the bond that you actually have put up, FCS puts up, is it a certificate of deposit or is it a surety from another company or is it cash?
That we put up. Please clarify.
Well, actually, you said earlier that it's $10 million in assets, right? To have
Correct.
Okay, so $10 million in assets. Does that have to be backed by a instrument, or is that simply substantiating $10 million in assets available to satisfy an obligation?
The answer to your question, frankly, is very complex. There are overall rules that relate to how much what we call statutory surplus is required. And then there are state-specific, county-specific, and municipality-specific rules that may require posting of specific collateral.
Okay.
Now, in California, that is not the case, but in other jurisdictions, it is. So we have to comply with whatever the rules are in any jurisdiction in which we wish to be licensed to issue bonds.
So in California, though, you don't actually have to put up a specific collateral to back these surety bonds. Is that what I'm understanding?
That's correct.
So when it gets to civil process, that's not something where they're going to take your cash undertaking and apply it to one of these bonds where the defendant did not appear.
Not in California.
In other jurisdictions, that would happen.
That would potentially happen in certain other jurisdictions.
Okay. All right, let's go ahead and go off the record and we'll eat lunch.
Off the record, the time is 12:57 p.m. Putting on the equipment. We are back on the record. The time is 1:38 p.m.
I'll show you 209. Some more recent filing. If you go to page 16, 209, really poor copy, but that's what the court had.
Okay. A little blurry.
That's not your glasses.
I hope not.
You see how they're using the name there, bail hotline, bail bonds / financial casualty and surety Inc.
I believe so.
Do you know if the bail hotline, bail bonds is bail hotline, bail bonds Inc. or is it's the DBA of DMCG or some other company?
Don't guess or speculate.
I'm sorry?
Don't guess or speculate.
My understanding is that bail hotline, bail bonds, is a DBA for DMCG Inc. But it's also my understanding that they incorporated under a kind of a just shell entity under Bail Hotline Bail Bonds Inc. as a means of protecting that identity.
Okay. Are you aware if DMCG or any of the McGuire brothers have filed a DBA to use financial casualty and surety without an Inc.?
Foundation speculation.
I don't have any knowledge of that, no.
Have you heard of Matthew Singer before?
Asked and answered. You can answer again.
I've heard of him now. I heard about him today.
Prior to that time, you've never heard of him?
No, sir.
There's a Ryan. For the sake of completeness, I'm going to give you a copy of what's going to be 205 as well.
Thank you.
Now, Mr. Shields, have you read the California Code of Regulations regarding bail Are you familiar with the regulations regarding bail under the insurance regulations?
We call for expert testimony and legal conclusion, but you can answer.
I can't say I know the rules or regulations completely. I mean, I've looked at specific ones in response to specific questions that have come up in my office, but that's really it.
Is financial casualty and surety authorized anyone to represent that a defendant who has absconded actually needs a continuance? Authorize a lawyer to appear on behalf of that defendant despite not having engaged the lawyer and request a continuance in order to avoid forfeiture of a bond.
Foundation speculation. Calls for legal conclusion.
Not to my knowledge, no.
Mr. Shields, have you or your predecessor authorized Michael Singer to appear in court and represent that he represented a criminally charged defendant and request a continuance?
I can't testify as to my predecessor, but I have not done that.
Okay. Have you ever seen or read 10 California Code of Regulations 2071?
I couldn't answer that without seeing it.
Okay, you can mark that as F.
That has 2071 and another statute as well.
2091.
I'm sorry?
2091 is also on
2090.
here.
And this is F as in Frank?
Yes.
Thank you.
No? Am I past that?
E as in
E.
echo.
Okay, E.
And counsel, I assume you'll make a representation as an officer of the court. This is a true and correct copy of the statute.
That's what I downloaded from the net. So.
Okay. All right.
I have not read this provision previously,
Okay.
but I've read it now. It's fairly short.
And the following provision, the next provision as well.
2091 of the Code of Regulations.
Yes.
Essentially, I've not read this specific provision previously, but it seems fairly straightforward in terms of reading it.
Okay. Were you familiar with these with these limitations on business practices of a bail prior to coming here today?
I was not specifically familiar with them, but I would say that intuitively they make a lot of sense.
Okay. Because if we look at,
I gave you 207, right?
No, sir. 2071?
2071?
No, the exhibit
Oh.
207.
Yes, sir.
I do not have 207
You sure about that?
unless it came this morning, so give me 1 second, Scott, if it's in its pile.
Here's this copy of
Oh,
it.
that's 209.
Oh, that's 209. I'm
Yeah,
sorry.
I don't think we have 207, Scott?
Jessica?
Okay.
Okay. Well, let's keep digging.
Yes.
That looks like one of my sevens.
It looks like this.
All right, let's find it.
I'll check, but I don't recall it.
I misspoke. We do have 207 now. We just have
Yeah, there it is.
Okay. Sorry. Thank you, Jessica.
Okay. This is our case again of Angelo Brown.
Yes, sir.
If we look at 207, page 305. And I gave you exhibit 209.
That we have.
That was
Yes.
the The one with the, no, actually, this one here.
Oh, that's 205?
205?
Yep. Yes.
All right. You see there on page 3 of 5, Exhibit 207, there's a footnote. Footnote 2. Do you have, I'll let you read that real quick, and I want to ask you a question.
Okay, I've read the footnote.
Okay. Has financial casualty and surety prohibited its agents from engaging lawyers to appear on behalf of criminally charged defendants?
I can't testify as to whether that's been specifically prohibited in any particular matter, but we do emphasize to our bail agents that they're required to comply with all applicable rules and regulations.
Is there anything more specific than that, other than you're required to comply with applicable rules and regulations?
Not that I'm personally aware of, no.
Okay. Are you provided? Oh, I think I've asked that already.
Madam Videographer, are the Coke cans in the water out of the screen? Thank you. Or out of the frame? Thank you.
Okay, I need the website part.
You're done with
It's Pepsi.
that. Oh. That's why she said
I don't know
no.
if it makes it different.
What is a reassumption of liability on a bail bond?
May call for legal conclusion, expert testimony. You're free to answer.
I'm not an expert on that, but my understanding is it's essentially a reinstatement of the continuing liability on the bond.
What are the circumstances that those are issued?
May call for legal conclusion on incomplete hypothetical, but you can answer.
To my knowledge, it's a very rare circumstance if it happens. And we don't see that very often. I don't think we've seen a single one since I've been serving as the president of the company, but I don't want to say that it's not possible
It's
we've
never
done it.
happened.
Yeah, I was going to say. I don't
Missing a
know.
binder. Is there one more binder? 186. Yeah. Oh, wait, here we go. This is right in front of me. Okay, can you pull 186, please?
Thank you.
From your understanding, why would this be, why would Financial Casualty and Surety, Inc. reassume all of its obligations thereunder?
Foundation speculation, legal conclusion.
Honestly, don't know.
Okay, Okay, you see an order of bail forfeiture is vacated and bail is reinstated.
I'm sorry, it's
Bail forfeiture is vacated and bail is reinstated.
Yes, I see that.
And you authorize the defendants, McGuire, DMCG and McGuire Brothers collectively to obtain reassumption of liability on bail bonds and the associated orders, correct? You being financial casualty insured.
I can't affirmatively state that we specifically gave authorization to do that in this particular case, but I would state that they would have the authority to do that under the terms of our agreement.
Have there been instances where you actually told defendant DMCG that they did not have authority under the agency agreement to do anything that you're aware of?
I'm not personally aware of any specific instance where we're advised in advance of some action or activity that would be outside the scope of our agreement.
Okay. Have you learned of any activities of DMCG which are not in the scope of, course and scope of the agreement, the agency?
To my knowledge, no, not specifically.
Now, you reviewed the documents at length, or to some extent, before you came here. In your review of the documents, had you ever seen any instruction to DMCG regarding anything?
Questions vague and ambiguous, calls for speculation. You can answer.
And specific instructions on any topic?
Anything, like send us in your reports. Has any demand ever been made to DMCG?
Questions vague and ambiguous, compound. You can answer.
I think that there's routine correspondence where questions are exchanged and answered with regard to reporting of specific bonds, tracking of specific bonds. That's a routine part of what we would be doing with that.
Okay.
In other words, our focus is on the accuracy of our accounting and reporting and our regulatory compliance. I don't really recall any specific situations where we felt that we had been advised of representatives of DMCG taking actions that were either not permitted under the applicable statutes or not compliant or in accordance with our agreement. But there's correspondence, there's communications between the employees of our company and the employees of their company on a regular and routine basis.
Okay, I understand that, but has there ever been any tension that you've seen or have heard of, or as the representative of Financial Casualty and Surety, where Financial Casualty and Surety told any of these defendants to do anything or not do anything?
Questions vague and ambiguous, compound, calls for speculation.
I'm not sure how to respond to that. I mean, we've had discussions with them on an ongoing basis about the day-to-day operations of the business. We've had discussions with them whenever questions came up from, regulatory authorities in California. In fairness to them, they've always been, in my view, very reasonable to deal with. They've always been responsive, And I've not had any complaints from our staff members about their conduct or their behavior of their employees.
Okay. I'm not ignoring you. I'm trying to find an email that I had a question in it. That's some very specific language. Okay, Lisa Fernandez. She works for Financial Casualty and Surety.
Yes, sir.
Is her salary paid for by Bail Hotline?
Foundation?
No, sir.
Did Lisa Fernandez work previously for Bail Hotline?
Let me clarify. Her name is actually Lisa Hernandez.
I'm sorry. I'm just reading from.
Okay, because our employee's name is Lisa.
Lisa Hernandez. I'm
Hernandez
sorry.
with an H.
I'm sorry, and it was here in front of me. What I was reading from had her name misspelled.
Okay.
Was Lisa Hernandez a Bail Hotline employee?
Not that I recall, no.
Is Lisa Hernandez actually stationed there does she reside in the Houston area? Does she actually work in the Houston office?
Oh, absolutely.
Does Financial Casualty and Surety have any employees that are actually working in the Riverside office?
Clarification, the Riverside office
Riverside, California,
for anybody?
for anybody.
No, sir.
Are they paying for any independent contractors in California?
No, sir.
I'm wondering if one of the Fernandez may actually be an employee that works in California.
Sorry?
Fernandez may be an employee that works in California. That's what it's looking like,
Oh.
by way of clarification,
For who, Scott?
for the record.
Oh, no, I know clarification for the record, but you don't mean for FCS, do you?
No.
Okay.
Do you have a company, do you have a person that works in Financial Casualty and Surety that's assigned to liability management? Is that a title?
No, sir.
Financial Casualty and Surety receives weekly and monthly bond reports. Is that correct?
We receive reports frequently because some of our clients report weekly, some report bi-weekly, some report semi-monthly, some report monthly. It depends on the volume, quite frankly. We have smaller clients who don't write that many bonds who report monthly. We actually have some that report every other month.
Is the reporting dependent on the size of the bond? For instance, we looked at this email exhibit on between Jennifer Velez and Lisa M. Hernandez, and those were $140,000 and $100,000 bonds.
Yes, sir.
So depending on the bond amount, do you require more reporting? Financial
sir.
casualty and surety, does it require more frequent reporting?
No, sir. The frequency of the reporting is really more of a function of the number of bonds issued. And the reasoning behind that is because whether a bond is issued for $100,000 or $1,000, the reporting process for it is the same.
Okay, by reporting, you mean that they need to report to you. You're not required to report to anybody other than at the end of the year to the regulators, right?
Well, we are worried or concerned about staying current and getting all information captured in our systems. And to do that, we need to even out the workflow. In other words, we want to keep our employees busy during their regularly scheduled hours, but we want to try and keep that a consistent volume. So we work to, as an example, if we have people reporting every other week, we're going to have some reporting the first and third week of the month and others reporting the second and fourth week of the month, so that we can keep the workflow even and maintain stability of our staffing levels. It's just to be more efficient.
Okay, with respect to the material that was produced, what material was not produced?
Questions vague and ambiguous, assumes facts, not evidence that there weren't documents produced. Unresponsive. Also may call for legal conclusion.
I believe we produced everything that our attorneys advised us to produce.
Okay. Because this relationship between DMCG or the McGuire brothers and Financial Casualty and Surety has gone back since 2009, correct?
Yes, sir.
So we're in 2018, so that's 9 years.
We consider that a short to mid-term relationship.
For 9 years, I guess there's about 1,500 pages. So
Is there a
that's
question?
not very many pages. Would you agree for that term of relationship?
Speculation, foundation, argumentative.
I don't know what you mean by that's not the right number of pages.
Well, I mean, it's less than 200 pages per year.
Relevance, foundation,
Do you
speculation.
see what I'm saying?
I don't.
I wasn't asking
No, I
you.
really don't.
Do we have some meaningful questions, counsel?
Do you want to suspend?
We're here till
Say
2:30.
yes, I suspend. We don't need to do the dance.
We're here till 2:30, as we told you.
The fist,
So
the chest thumping.
it does. I'm not chest thumping. That's this. It sounds like we don't have any more substantive questions. I'm just curious if you're going to drag us through this, or we can be released, counsel, from the torture.
I don't have to talk to you.
No, you don't, but you always do, and you're a nice guy.
Okay. The nature of the communications. I understand that there's reports. It looked like there was reports here about bonds.
For instance, this one that I showed you from Lisa Hernandez, there's updates. Large bonds, total 240K. When they would send you the updates,
They send the updates on the bonds. Is that always sent between the same two people?
For our side of it, it's always Lisa Hernandez because she's been working on this account really from the inception, and she's a great long-term employee. And I think from the perspective of Bail Hotline, I don't think there's been that many different people on their side of it either. So I think there's pretty much a consistency to the people that work together.
Who are the people that work together between Bail Hotline and Financial Casualty and Surety?
He's not the person most knowledgeable. Actually, strike that. The notice did not ask for the person most knowledgeable, familiar with the people who are regular employees at DMCG, so that's beyond the scope.
I mean, I can answer Lisa, because Lisa's been working on this account for us for really ever since she's been with us.
Thank you. And who are the other people that are assigned to handle the McGuire Brothers and the affiliates account?
Terry Cressy is our agent relations person. And then really just me since I came on board as the president. And before me, our retired officer, Mr. Sapo.
Now, what I had Mr. Sabo down as he was an executive vice president when he was signing the bonds.
Yes, sir.
Did he change? Was there another president before you?
Our chairman used to be ostensibly the president. He's one of the owners.
Okay. And what's the chairman's name?
Myron Steves.
Is he still alive?
Yes, sir.
Did he have, from your understanding, was he involved in the recruiting of the McGuire brothers?
No,
What-
sir.
You need to pause a second because she can't type if both of us are talking,
Oh,
but
I'm sorry.
your answer will
It
stand.
was such a simple answer. He's not actively involved in the company, sir.
Not, he wasn't ever actively involved?
Foundation speculations.
Not actively involved. He's in his mid-70s, and he is our chairman, and he's one of our 3 stockholders. And his family excuse me, is the capital provider for the company. So his relationship with the company is mostly as chairman. It's kind of ceremonial. He's never been involved in day-to-day recruitment or operations or working with our agents.
He just was putting his name on the bonds as essentially a vanity. Well, actually, it was Mr. Sabo that was doing that, and then...
Correct, but I wouldn't say it's vanity. I mean, it's his. To be honest with you, it's his family's company.
Yeah.
It's their money.
Sure, sure. What time is it?
We got about 20 minutes. It's 2:09, turn 2:10.
All right. Do you know the manner in which the FCS avoids forfeiture of its bonds issued through defendants?
Assumes facts.
Please state again.
Do you know the manner in which FCS avoids forfeiture of its bonds issued through the defendants?
Assumes facts. You can answer.
I'm not sure I can say what the manner is. We rely on DMCG to underwrite and administer their business. And to be frank with you, it's been a very good relationship for us because we've done well with them financially. They've been responsible about the manner in which they manage their business. And so, to be frank with you, I don't go to them and question how they do this or how they do that. And to be frank with you, when they come to me, usually we talk more about overall financial objectives, tax issues, and things of that nature. And I think that's principally because that's my expertise. And that's what I usually am discussing with them.
Who was the person that was, would you say, would be most knowledgeable about the scope of authority of defendant DMCG Inc. at the outset to act on behalf of FCS?
At that point, most likely, Mr. Sabo,
Okay.
my predecessor.
Did he leave under good terms?
Asked and answered. You can answer it again.
I didn't ask that question.
You can answer it again.
He retired. I think he left under good terms. He's an older man. He's in his 70s now, too.
Does FCS, does it have a cloud-based email system, or is it on server?
Relevance.
I'm
You
sorry, or is it?
A cloud-based or server?
Relevance. You can answer.
We've always used Microsoft. For a number of years, it was on a server. You know, it was a server-based traditional system. A couple years ago, we switched to the cloud-based system.
Okay. I'm understanding that you don't recognize the term bond forfeiture avoidance. Is my understanding correct?
Well, I recognize it now because you brought it up several times today, but it's not a term I had dealt with previously.
Had you met Carmen Lanus before today?
I've met her a couple of times, never really worked with her directly, but I've met her a couple of times, and so I do know her, yes.
When was the first time that you met her?
The first time I met her was when I took a trip to, this was after Mr. Sabo retired, and I was, appointed to replace him, so I made a trip to their home office in Riverside to meet the McGuire brothers in person. I had talked to them a few times on the phone just as an introduction, and I met Carmen at that time.
What month was that?
I don't recall the exact month. It was last year sometime in 2017.
The early part or the later part?
Probably more towards the middle of the year.
In the summer?
Don't guess or speculate, sir.
I don't recall the exact date. I could look it up, but I don't recall it offhand.
Prior to that time, had you ever met the McGuire brothers personally?
No, sir.
Had they ever been to the office, as far as you're aware, in Houston?
Oh, I believe they've been to the office in Houston, and the reason I would say that or testify to that is because I know that a number of the employees that work in the Houston office had met them and knew them and had met them in person.
When you met with Ms. Lanus, who else was present?
For DMCG, it was Daniel, Caesar, Gilbert, and Marco, and Carmen. And from our office, it was myself and Miss Carey, and then also our lobbyist, our legislative advisor, Mr. Miller.
You have a lobbyist. FCS has a lobbyist.
We hire a lobbying firm, yes, sir.
Huh. Okay. And what was discussed?
At that meeting, primarily the legislative agenda for the California Assembly.
Was the case discussed?
Oh, God, no.
Okay.
No, the first I found out about this case is when I got your request.
So you'd never heard about the case until the notice of deposition?
I had heard that there was, a pending matter, but I had not really had any knowledge of it.
And you're not aware of any other pending matters against FCS related to violation of the labor codes, correct?
Not that I'm aware of.
Never heard of Norfolk? Lewis Norfolk?
That's beyond the scope of the notice. Also irrelevant.
Okay. Well, had you
To my
ever heard of Lewis
knowledge,
Norfolk?
no, sir. No, sir.
So I'm understanding that you went there to their office with the corporate counsel for FCS. Is that correct?
Yes, sir.
Go ahead. And how long was your meeting with them?
We met with them for a couple of hours at their office, and then we went to a political fundraiser that they had asked for our assistance with. And, you know, after the fundraiser, we had dinner with them, and then we flew back the next morning.
Very exciting.
I'm sorry.
I was being flip. Don't worry about it.
Okay, how do you invoice the defendants? Or do they just pay you?
We don't invoice. We use a very traditional system within the property and casualty insurance environment, which we refer to as bordereau reporting.
What?
Bordereau reporting.
Bordereau. Okay.
What that means is that a binding agent, such as DMCG, they submit reports to us, in their case usually semi-monthly, and they report the bonds that they have written for us, and they report how much premium was collected on the bonds, and they remit payment in connection with those bonds at that time. We review the report. If we have any questions or we think there's any adjustments or any corrections, we deal with them directly to ensure that our systems are, you know, complete on their side and our side, that we have accurate reporting. And that's what we call bordereau reporting. It's very typical in the property and casualty insurance business for bail agents or other types of agents, general agents or other types of insurance agents. And it's typical to a, you know, at what we call a binding authority type process.
So essentially it's on the honor system.
It's on the honor system. Our control feature is that we provide the powers, and all powers have to be accounted for.
By powers, you mean pre-printed bonds?
Correct.
Which have serial numbers on them.
With unique serial numbers.
And how often does the accounting take place?
In the case of, you know, the DMCG account, it's semi-monthly.
Okay, and they report what's happened with the powers of attorney through its email, or is it through an online cloud-based system?
No, they actually mail us a report.
And so somebody on your end goes and punches that into another system?
Yeah, it goes into our management system.
Okay, it's done, there's actually a physical mail copy, or is it an email report that they send you with a spreadsheet?
As it stands right now, it's the latter. It's a printout. It's done with a spreadsheet, and it's sent to us. We're working on, you know, technology innovations to automate that process, but we haven't completed that yet.
And then once it gets to you, you scan it, or what do you do with it?
We retain it.
So you just put it in a file. You don't have a scanner, electronic imaging system.
We have scanners, yes, but it goes to accounting and it's retained there.
Right. And I actually did designate 56 as all email systems.
I didn't object to that line of questioning, counsel.
Okay, so what about the document retention policies of SCS? What was the last?
Document retention policies vary based on state reporting requirements or state statutory limitations requirements. California, as I recall, is a 5-year statute. And so we're obviously going to be compliant fully on 5 years, and then we're going to be compliant on anything that might be older than 5 years but is not completely resolved, exonerated, or otherwise.
What about this, the documents related to this litigation? Was there an instruction to stop just purging documents?
Oh, excuse me. Question assumes facts, not in evidence, that there was any purging of documents regarding this case. Calls for speculation. Misrepresents the evidence and the facts in the case.
I'm sorry.
Miss-
Purge it, Doc?
I believe
Purging.
Purging is the word Mr. McMillan used.
Did you put a document hold on the documents that could be associated with this case?
Yes.
When did that document hold go on?
That would have been put on by legal back at the time they were notified about the matter. I don't remember the exact date, but it was in sometime in 2016.
What time did we have?
2:21, about 10 minutes if you can, please.
What does Terry Cressy, what's his job function?
Terry Cressley is one of our agent relations managers.
Is this his account, the McGuire's?
It has been assigned to him recently.
Who was the relations person before him?
Mr. Sabo.
So they were dealing directly with Ron Sabo.
With
The McGuire's were dealing directly with.
he assigned the account to himself. We have added to our agent relations staff since his departure. He was very much a hands-on kind of guy, and we've changed our approach a little bit because I'm not quite the same type of leader as he is. I'm more about building a transitional, generational organization, with long-term value. So we now, whereas under his command, we had never more than 3 agent relations personnel, including himself. Now we have, we have 6, and we're still looking to expand and bring on another 1 or 2 people.
And Mandy Krasny, what's her?
Mandy Carey.
Mandy Carey, Nee Krasny. What is her job function besides just being the lawyer?
Her primary function now is legislative relations. Our business has been, become a central focus of the, criminal justice reform efforts. And so we are facing legislative activity in most of our key states where we produce our business. And so we are spending a lot of time, effort, and resources to address that, to try and preserve our industry.
Okay. So was she actually involved with these people?
Oh, she's worked with them, yeah. She's a vice president.
Okay.
And
Besides,
when Bob, decided to retire, she helped with the transition.
Okay.
Because I was coming in new. She's been with the company for a number of years, and so she worked with me and helped me kind of get to know them and meet them, and we're just trying to evolve to keep our business vibrant and successful, and it's a changing world out there, and we're trying to change with it.
okay. Well, I think that we better get you on the. We're going to get you out of here at 2:30 so you can take your.
Well, thank you very much. I appreciate your courtesy.
Without prejudice to doing this again,
Thank you, Scott.
Thank you.
because I didn't realize we had a limit.
How do you want to handle the transcript? Really?
Oh, well, what's your, I'm not gonna,
Hang on a second.
he can review He can review an electronic version and sign it, that's fine, but otherwise per code.
Well, can we go off the record for a second, and let me make the
Sure.
proposal to you for your consideration?
Off the record, the time
not
is
gonna do the standard one.
2:26 PM.
Okay, so what I was going to say,
Hang on a second.
The
We're back
stipula-
on
Sorry.
the record, the time is 2:28 PM.
Hey, the stipulation, we're going to follow the code except for the following respect. Mr. Shields may verify the corrections to the deposition, and Mr. Shields, correct me if I'm wrong, use notaries in Texas, right?
Yes.
Okay. So any corrections that you make within 30 days of receiving the deposition, actually, can we make it 2 weeks? How long do you need to read the
well,
deposition?
hang on, Scott. If you're going to ask for shortening of time and all this, and we're going to have to do it by code, that's going to make things much more cumbersome. He's out of state. I can't really do that.
Okay, let me just go per code.
Sauce for the goose is sauce for the gander, counsel. I'm
I'm trying to work with you. Told you I'm not giving up my original, okay? I'm not giving up my original. And I'm willing to accommodate so he doesn't have to appear, but I do want a notarized signature on his verifications.
I wasn't fighting you on that, counsel.
And I do need it sooner if I'm going to be doing that. But if you don't want to go along with that, then we don't have to go along with that.
I'm trying to figure out a way that we can bridge the gap, because this isn't rocket science, Scott. So is there a way that he can review and sign it? When will the transcript, given its length, when will it be available?
Standard turnaround time is about 10 to 14 business days.
And approximately how many pages do we have?
150.
Okay, so it's not, do you have any trips planned in the next 3-4 weeks?
There'll probably be some, but if it comes to me electronically, I can review it from anywhere.
Okay. So Scott, why don't we do this? Why don't we...
And I have a notary that...
Okay, so why don't we say 21 days from receipt?
Okay, and he's going to provide a notarized verification transmitted to, with the original sent to the court reporter. And we will agree that that will suffice as the verification of the transcript.
Texas notary, okay.
Texas notary's fine.
All right, so then the court reporter will notify all of us that she has everything packaged and back.
Yes. Well, she'll attach that to the original and return that original to me. As if he would have gone to the court reporter's office and signed it.
Right, and will this be done electronically, or will hard copy be sent to the
Needs
witness?
to have a hard copy. No, the electronic you can have.
Send it back as hard copy.
Okay, you're buying a copy, right?
Well, if I've got his copy, I don't really need one.
No, you need to buy a copy.
Well, I want an electronic copy sent to me when it goes to the witness.
That's fine.
But y'all want a wet signature.
Yes,
I understand. That's no problem. I just wanted to do it right.
wet signature notarized.
Okay,
Return to Greta.
that's fine.
And see, this is the thing. I don't cheat my court reporters out of their copy orders.
I'm
Don't
not
do that.
suggesting anyone should be cheated.
Okay.
All right,
Cool.
sounds good. Thank you.
Off the record, the time is 2:32 PM.